Good morning, good morning, good morning. Now that my microphone has decided to let you hear the tenor of my voice, we are all here together today. Hi, everybody. It's Thursday. It's July 20th. I have an exciting announcement for y'all. We're going to talk a lot about Idaho today. We're going to talk a bit more, I think, about the TikTok defamation case than about everything else. That's really exciting. So that's what we're doing today. We're going to talk new filings in the Idaho criminal prosecution, new filings in the defamation case, including a motion for sanctions that took every bone in my body to not read last night because I was so curious. I was like, I want to talk about it. I want to talk about it. I want to talk about it. And I wanted to read it. And I was like, no. We're going to read it together. We're going to read it together. I'm very interested to see what this motion for sanctions is about. We'll talk a little bit about what's going on with the Erika earrings that I talked about in the podcast yesterday. Did you guys listen to the podcast yesterday or watch the podcast video, podcast, wherever it is? Let me know in the chat if you've already heard the podcast. If not, I'll catch you up in just a second. So we are going to get rolling with all of that. I have a few things to share. Well, I have an announcement to share first. So we're going to do that before we get into quick bits. I think I forgot to update this somewhere because I sat down and was like, I'm ready to go. And then my microphone was like, who do you think you are? And I was like, oh, okay. We're maybe not as ready as we thought we were, but now we're ready. All right, y'all. Let's roll it. A lot of you listened to the podcast. Thank you. So it'll be quick and easy to kind of update you. I have thoughts just from stuff that went down yesterday. Oh, and I just have a little bit of an update from Rob from Lawn Lumber, who shared some stuff on Twitter. And then we were chatting more about bankruptcy behind the scenes. He practices more in bankruptcy than I do. That's for sure. Me practicing in bankruptcy, zero. So we're going to talk about that. All right. Are you ready? Kaylin was like, when do we actually go back to court? We were in court on Tuesday. So that's on Tuesday's show. And those are all timestamped, just like this one will be, because the replay crew, we love you. And we know sometimes you just want to get to the shit that you want to hear about first. All right, let's roll the intro and let's get going. Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it. All right, y'all. I'm just getting my chat popped out so I can see it because it didn't get done before. Because we're professionals here and sometimes that happens, but we have a bunch of things to talk about today. So first, we are going to go to an article. This is kind of our quick bits. Well, this is my announcement. I guess it doesn't get the quick bits intro because it's an announcement, right? That seems like the right result. Hold on. Why won't this share? Me still trying to do 10 things at once. Give me 30 seconds. Chat's like, no, we're fine. It's fine. We're going to give you a rundown of the Girardi pod. No, I'm going to make my announcement first. Once I tell Instagram that I'm live, which doesn't seem to want to be working. Grr. All right. Maybe it will. Maybe it won't. Let's just cross our fingers and hope for the best. All right. Hopefully that's today's live video that got shared. If you're in the Instagram stuff, it may or may not be today. Today's live video. I thought it copied it right. Maybe it did. Maybe it didn't. We're just going to send it. It's totally fine. Let's talk announcement real quick. So today I have a new project that is dropping for all of you. Oh, Instagram audience. This is completely the wrong link. This is a link I was sending to people yesterday. Today doesn't want to work for me. That is something in retrograde. The tech is just like, hey, Emily, what's not happening today is this. Sorry to the Instagram folks. This is well, if they haven't gotten the announcement yet, they're not here because it just won't share. We're going to try one last time. But anyway, I have a new project out today that I am really, really excited to share with you. It is something that I have been working on literally for months and months and months. And it's exciting for me to be a part of a different kind of a podcast. And I am part of season 4 of Queen of the Con. Episodes 1 and 2 drop today. So let's go to this article real quick and talk about it as we go. So this is coming from The Wrap. They shared this yesterday. Jen Shah will be the subject of Queen of the Con podcast's 4th season exclusive. The former star of Real Housewives of Salt Lake City is currently serving a 6-year prison sentence for conspiracy to commit wire fraud. Jen Shah may no longer be on the Real Housewives of Salt Lake City, but her story continues to fascinate the public. The former reality TV star, who's currently serving a 6.5-year prison or 6.5-year prison sentence for conspiracy to commit wire fraud, is subject of the Queen of the Con podcast's 4th season, which debuts July 20th. That's today. So you can go to your favorite podcasting app right now, iHeartRadio, Apple Podcasts, what have you, and download the first 2 episodes and support me and support the show. According to a press release, the series, titled The Unreal Housewife, will feature exclusive interviews with childhood friends. It does. I've heard the first number of episodes, and I've worked on those episodes on who the interview is going to be with, and I'll talk more about that in a second. But the interviews with the childhood friends start in the beginning in the first 2 episodes, and they are really, really interesting. I think they're really, really interesting. So childhood friends, former neighbors, ex-employees, as well as several of Shaw's victims, and the federal agent responsible for putting her behind bars. The 8-part series will uncover shocking new details about the housewife turned convict's backstory, rise to fame, and spiral of decisions and events that ultimately led to her arrest and conviction. TV producer and quote-unquote con hunter Jonathan Walton, me not saying Jen, Jonathan, I'm sorry. My brain is already stuck in Jen Shah land today. Jonathan Walton investigates and hosts the podcast and executive produces alongside Air Media founder Eliza Rosen, who's wonderful, attorney and popular YouTuber. Thank you, Lawrence. Thank you. Attorney and popular. I will take it. Oh, and I'm going to tell my kid and be like, look, this says popular YouTuber. It says popular YouTuber, Griffin. That's what we're doing. Attorney and popular YouTuber and podcaster Emily D. Baker, who has covered the Jen Shah case extensively via her channels, is featured heavily throughout the series and also serves as a consulting producer. I did. So this is not just a podcast I was involved with giving commentary. I got to work from the early stages of this podcast behind the scenes as a consulting producer, and I was really excited to be a part of that. The series is distributed by iHeart Podcasts. What viewers saw on TV barely scratches the surface, Walton told The Wrap exclusively. This season of the podcast features new accounts of Jen Shah's scams, starting at the very beginning, from interviews with her former classmates to firsthand accounts from several of her victims. She used multiple cell phones to run her schemes, and we got our hands on a bunch of text messages that completely contradict everything Jen Shah has said publicly. I'm a reality TV fan and a Housewives fan, so of course I was both riveted and horrified by Jen's story, added Rosen. Isn't that all of us, or a lot of us, Housewives fans? Is that you? Riveted and horrified? Like there's a morality part of it where you're like, I can't watch that. And then you're like, I can't stop watching it. It's terrible. I feel the push-pull of it too. I really do. As news continued to break on the scope and particularly despicable nature of her crimes, I knew she had to be our focus for this season of Queen of the Con. There were still so many questions and so much left to be uncovered. I think listeners of the podcast will come away with a much deeper understanding of who Jen Shah is, what set her on this path, and the devastating effects of her actions on so many people. I'm excited to join Queen of the Con Season 4 as a consulting producer, said Baker. I did say that. This role allows me to break down the legal side of how this fraud operated, why it was successful for so long, and what took it down. Reality TV audiences have never seen a federal prosecution unfold in real time, from arrest to plea and sentencing. This season digs into what cameras didn't catch and the strength of the evidence against Jen Shah when she pled guilty. Shaw's castmates and viewers were shocked when law enforcement descended on production to take Shaw into custody just as the housewives were preparing to take a cast trip. Citing a medical emergency, Shaw left the scene just minutes before agents arrived. She was taken into custody later that day off camera. The scene was included as the feature of the Real Housewives of Salt Lake City season 3, which featured the aftermath of the arrest. Shaw, one of the original castmates on the show, did not show up for the season finale due to her ongoing legal woes. She began serving her prison sentence in February 2023. So we're going to go to the trailer real quick. You can download this on the iHeartRadio app and your other favorite podcasting apps. If you want to hear this, Queen of the Con focuses on con women. So if you are very interested in financial crimes, fraud crimes, and con artists, Queen of the Con has 3 other seasons. So after you go and listen to the first 2 episodes and let me know what you think, then you can dive back in for more. So let's go to the trailer for Queen of the Con real quick. I'm so excited to share it with you. All right, let's hope I do this right.
I'm the Wizard of Oz.
Wait, I want to be on screen too. Hold on. Let me do this better. Let me do this. Let me remove that.
I'm the Wizard of Oz. I'm like the one behind the curtain that nobody knows exists, but I'm the one making everything happen.
Real Housewife of Salt Lake City star Jayne Shaw is running the scam of the century.
We probably will never be able to be retired. We'll have to work until we can't work anymore.
Living a fat $1 million lifestyle on the backs of thousands of elderly victims.
It was awful what she did to those people. She turned up their lives for what, a fake Fendi bag? Congrats, girl.
When you have her confronted by another government agency, and instead of stopping, she finds ways to be sneakier about it and keeps going.
If you had to explain to a 5-year-old what Jayne Shaw is guilty of.
Jayne Shaw stole money by lying.
She took everything from these people and expected everything to be given to her.
But did growing up as an outcast in Utah lead Jayne Shaw to a life of crime?
I went to school with Jen. Orem Junior High School had a reputation for being a very rough school. People were mistreated.
Hear eyewitness accounts of Jayne Shaw's scams in progress from the people who were there.
I remember one time Stuart lost like about $8 million, and Jen was very upset, and she came down to the office late at night with Coach, yelling and screaming at him, asking him where their money is.
Jayne Shaw's betting that being an outspoken reality star will render her untouchable.
The feds love to make a spectacle out of somebody. They're not going to shy away from that.
Would you call her a con artist?
I would just call her a con. She's not very much of an artist.
Listen to Queen of the Con, Season 4, The Unreal Housewife, on the iHeartRadio app, Apple Podcasts, or wherever you get your podcasts.
Y'all, one of the things that I was surprised about in this trailer is, one, when we recorded all of our podcasting, they were audio only. So when Jonathan put my face in there, I was like, Jonathan, that is my off-camera face. But also I'm like, whatever, the internet has seen me look. The internet has seen me look off-camera face anyway. But the story from Koa, who worked for Jayne Shaw, talking about Stuart losing money and Jen and Coach confronting Stuart Smith about the lost money was shocking to me. I was like, this is the first time we've heard, and this is the first time the stories will be shared about what Coach knew with these cons and with the money going missing and the conversations that others witnessed with Coach Shaw and Jen and Stuart Smith. Stuart Smith is going to be sentenced in September, but we've not seen anything with regard to what Coach may or may not have moved or may or may not have known. And I am excited for you all to get to hear this episode or this season of the podcast, these 8 episodes, because it's really, really fascinating. And I love the way Jonathan has put it together. I've not been part of a podcast that was produced like this. The amount of work that goes into a produced podcast like this is so very different, because I do a kind of on top of it breaking news podcast. And while we have incredible editors, it is a whole different type of podcast than doing a podcast like this. So I can't wait for you to go listen. So any podcasting app, Queen of the Con, season 4, the first 2 episodes dropped today. And if you didn't watch any of the Real Housewives and you're just interested in the story, this will bring you up to speed on the story. This podcast isn't glorifying Jen Shah and what she did. It's also not shitting on Jen Shah. It's exploring Jen Shah, who she was before this, how this played out on TV, what the charges are, and what's going on. So, question, who is Coach? Coach is her husband, and you will hear more about that in the first 2 episodes. So go check it out. I hope that you will find it interesting. So, Maria asked a great question. Would love to hear you cover what's going on with the Elisa Turney case. I talked a little bit about double jeopardy. I think I'm going to break it down more on next week's podcast of the Emily Show, which means other topics keep getting bumped, but I think there's more that I can help break down there. So that will be next week's podcast. Congratulations on the new project. Thank you. It looks excellent. Where can we check it out? It's a podcast. Queen of the Con is a podcast. You can check it out on your favorite podcasting app, iHeartRadio, iTunes, or not iTunes, Apple Podcasts. me being old iTunes. It is on all of your favorite podcasting apps. So Spotify, what have you. Anyway, you don't have to get whatever one you use, you can get it. You don't have to get a Spotify app. You can listen on iHeartRadio or Apple Podcast. Just audio. It is an audio only podcast. And the other 3 seasons are excellent, which is why I agreed to sign on. I was so happy to join with them and join on as a consulting producer. It's something that I haven't done before. It was a great experience. The team behind Queen of the Con really does fantastic things. So there you go. What are the other seasons about? Who are the other seasons about? I would have to pull up a list because I'm not going to remember off the top of my head. So you would have to pull them up. The first episode or the first season deals with Jonathan's story because he was a victim of a con artist, and it dives into his push for justice and how difficult that can be. Lacey said, question, I just want to know if EDB is going to follow this Carlee Russel stuff now that it's been discovered that she was faking her whole abduction. We're going to talk about that real quick in quick bits because I knew that you guys would have curiosity around that. So let's do a little bit of quick bits and then we are going to move on. Thank you guys for all of the love and support. Go support the podcast, even if you don't get to listen to it today. But if you do, great. Go download the podcast wherever you listen to podcasts. It will be fantastic. I've heard the episodes. I know they're fantastic. All right. Let's go to Quick Bits, shall we? Where is my Quick Bits bumper? There it is. Quick Bits. I'm sure a lot of you watched the Carlee Russel police press conference yesterday. I'm not going to break down the press conference live today. We have so much to cover live. I think that WFLA, JB does a great job breaking those things down. JB did that yesterday. They covered it. I find that JB's coverage is always ethical and compassionate, which is why I like tuning into what WFLA covers. So here's what I will say. If you have a lot of questions about this case and haven't watched the police press conference, just go watch the police press conference. It breaks down their investigation into Carlee Russel. If you did not follow this story, I was gripped by it like everybody else. The initial news coming out of this story was horrifying. She had called police and reported seeing a toddler on the side of the road, and they played that 911 call in the police press conference yesterday, reported seeing it. And then She called her like brother's girlfriend because she was coming back and bringing food from work after work, and called and said that she had seen a child, and then they heard a scream, and then the phone line stayed open, and then police got there like 5 minutes later and found her Apple Watch and her smartphone and her wig, and no child and no her. And that gripped everyone. Everyone was just like, find this woman. Like, this is terrifying. The tracking things are gone. Somebody has changed, it seems, her appearance or tried to. It was a lot of information, and the internet rallied. And in a big way, I saw TikToks that were purportedly from her brother. Her family was speaking out. People were asking for the internet's help. And after seeing how much the internet could help in a case like in the Gabby Petito case, you can see that asking for, hey, if there's any, truck drivers that have passed and you have dash cameras, or any drivers for Uber that have dash cameras, if anybody has dash cameras, can you find them? And they immediately pulled the traffic cameras, and started getting into every way they could find what happened or see anything that might have happened. And yes, a massive $75,000 reward. And then just 2 days later, Natalie's covering it later today. I'm so glad to hear it. And then just 2 days later, she was back home. She walked up to her home and knocked on the door, which to a lot of people is suspicious. But she was transported to the hospital, interviewed by police. Her family said she had spent that time fighting for her life. I don't think they lied about that. Whether or not she was abducted has come into question based on the police press conference yesterday. She had made some internet searches that the police called strange, including, do you get charged for an Amber Alert? At what age are you an Amber Alert? Or at what age do they stop putting out Amber Alerts? And search for a movie, searched about bus tickets, things like that. But also the police indicated that there were searches that were indicating what was going on with her mental state, and for her privacy, they weren't going to disclose that. Which I think is compassionate, but I also think indicates to a lot of us that there might have been a mental health crisis that was going on concurrently with this. And for that, I would say that there is a lot of room to give some space while the police continue their investigation on this. If she chooses to talk to police again, she might not. She might not choose to talk to police. If she has a lawyer, they are going to tell her, absolutely do not talk to the police anymore. Because we saw in the Sherry Papini case that Sherry Papini got charged for lying to law enforcement after faking her own disappearance. She was gone for longer. More resources were involved. But Sherry Papini also took victim assistance funds when she was recovered. And that is ultimately what she ended up being charged with, was the lying to police after they confronted her. So Sherry Papini was confronted like, we know you're lying. We've talked to the person you stayed with. Do you have anything else to say? And Sherry Papini kept on after that. And that's when they charged her with that and with taking the money from the victim assistance funds. In this case, if it gets dropped, will Carlee Russel be charged for the amount of resources that were put towards finding her? They may not. Will they charge her with making a false police report about a potential missing child? They may not. Whether they should or shouldn't is going to depend on more circumstances than we have. But at the end of the day, what I very much hope in a circumstance like this is that it doesn't change the internet's desire to help in circumstances where they're asked for help. And I think it's okay to say, some things might add up, but let's try to find the person safe and well, and then we can figure out what's happened, right? And I think there's room for asking questions. And I think that's appropriate, right? To trust but verify. And I hope that when there is another missing person case, because we know that there are too many that go missing without nearly the attention that certain cases get in the media, that there still is a push from the public saying, hey, can we try to find this person and then figure it out? So I hope that that continues, that the good-natured desire to help isn't tampered or tempered by whether or not this story was not all that it seemed at the beginning. And the police haven't come out and said that they thought that this was a hoax, that they thought she made it up. They came out and said there are a lot of things that don't add up here, and there is no threat to public safety, which is really what the police had to do in this circumstance, because all of those in and around this area in Alabama are like, okay, but if somebody is using a toddler as bait to kidnap people off the side of a fucking highway, we need to know. And the public does have an interest in knowing. And the police have said there is no threat to public safety. And they will continue to explore this. Again, she was returned home and safe. I'm sure those that donated, I think there was a GoFundMe. I think those that donated are probably very torn about it. I hope that we will get more information about what happened. I don't know if that will be forthcoming. I don't know if she will choose to talk to police again. I suspect that she won't. And again, I hope that she is okay, because this is a drastic measure. If this is a story that was concocted, this is a very drastic thing that might be a cry for help. So I hope we see what comes next. But the police, I thought, handled the press conference very well. They were just like, these are the facts of what we know. These are the internet searches that we saw. This was what was going on at work that day. This is the food that was picked up. But then she also went to Target. But then the things from Target were not still in the car. That was taken with her. So they kind of laid out all the questions and left those questions there. So if you're interested in that, it sounds like Natalie Lawyer Chick is going to be covering it again. Go look at the press conference. It's hard sometimes looking at other chats, because I'm so used to the Lawnerd chat, seeing some of the really vitriolic statements. I think a lot of people feel sad or frustrated because they were also so scared for her. I saw a lot of comments, and I got a lot of DMs of people who were like, this is terrifying because of the way that it went down. And if somebody is if somebody is trying to abduct people using a toddler wandering down the side of the highway, that is scary. If people are taking off your Apple Watch and your phone and leaving it and grabbing you at night, it is scary. And a lot of the public was very invested, was praying, and was worried. And so I think a lot of people feel really conflicted because of how much they were invested in this and how much they hoped that she would be found. And then the relief when she got home, but then also the questions that surround that. It's interesting to see. So I'm going to continue watching it. If there is, false information to police, obstruction of investigation, could the police go forward with that? Maybe they can. I think it's Ballet Main M, Balletto Main M. I'm going to pronounce that terribly because my brain can't parse it. What I'm confused about was there actually no toddler. From the police press conference, it seems that there is actually no toddler. There was not a toddler wandering down the street. And the thing is, once they pull the video and you look at the video, it's hard to see that there would be a toddler. What the police said specifically is there's no evidence of a missing toddler, and no one else called it in and said that they've seen something. What I have seen just from working as a district attorney, when there were events on the road, I would normally see, because we would get the logs If that ended up being something that was charged, we would get the logs. And when you get the logs, when there's something suspicious, a lot of people would call. Even if they didn't stop, but a lot of people would call. When somebody is on the freeway suspected of drunk driving or driving under the influence in some way, there would be multiple calls to law enforcement saying, I see this car, this is the license plate, this seems odd. The see something, say something, people take real serious. And the fact that there was no other calls is kind of telling, I would think, because at that time of night, there's a lot of people driving by. If you look at the video of the driving, there's a lot of people driving by. Also, the distance that she traveled on the side of the road doesn't seem that she was following a toddler. She was moving too far and too fast down the road, and then she didn't like back up on the side of the road. So there are parts of the story that just did not fit. And the police said that. I think they said it in a tamped down way. They said that there's, no evidence of a missing toddler, that the searches on the phone and on her work computer were strange, and that there's no danger to the public. So there's no concern that this is happening, that someone has done this. Ashley said, yep, I witnessed a hit and run, called emergency services, and was told I was the fourth person to instantly call it in. And that's the one thing. People generally want to help. I really do think people generally want to help. People want to help their fellow humans. I generally think that is the overall desire of most people. Not everyone, but most. So even if people couldn't stop, if they saw a kid on the side of the road, they would call. So, and people are good in an emergency. Witness said, yes, I think people are helpful in emergency. People are good in an emergency. You know what to do. It's like, there was a car accident. I should call and let people know about that. So it just is something where we will see, I think, more information about when law enforcement laid out that she had been searching local bus tickets, and then the movie Taken, which is based on an abduction, that was the moment in the press conference where I went, okay, we're probably not going to get much more information about this, because after this press conference, any lawyer that her or her family had talked to is going to say, do not continue talking to the police. Remember how Sherry Papini got charged. And this is the hard thing too with dealing with law enforcement and with dealing with the potential of a criminal prosecution. Her and her family and a lawyer aren't necessarily going to be comfortable telling the police everything. Arguendo, if this is all just completely made up and there's no real other underlying cause other than this was all made up. If that is the circumstance, it's very hard to call up the police and be like, okay, so I take it back, because then they might charge you. So it then puts you in kind of in between a rock and a hard place on, do you keep going? Do you stay silent, which I think might be the case here? Or do you tell law enforcement? Or do you get a lawyer to negotiate with law enforcement? Look, can we just agree to not prosecute her? And then we can go from there. And that's a hard thing too, because even if somebody wanted to say, hey, this is what it is, it might get worse, but it might get worse. So with whatever happens, this is not the way to go. If you are struggling, there are other ways to go about this. This is not the way, because at the end of the day, there are cameras everywhere and the police will figure it out. So look, a lot of the internet was hoping she was back safe. She was back safe. So there's that part of it. And now people want answers. I don't know if we will see any more answers than what we got in that press conference. So I don't want to get anyone's hopes up. And I'm not going to be diving it back in more unless there are charges. I covered the Papini case when there were charges. But I'm not going to cover this more. I don't know if police will charge it. The amount of money spent is probably substantial. So let's see. So we'll see. We'll just see what happens. But I'm not going to come on here and excoriate people on the internet either. I think there's still more questions to be answered. This wasn't as extensive as Papini. No, it wasn't. And we don't know enough. Could it be filing a false police report or obstructing an investigation? I would need to know more. Truly, I would need to know more. So we will see what happens. And hopefully the questions will be answered, at least for law enforcement, probably not for the internet. I just hope that this is, people take what the police say, but I have a feeling that the internet sleuths are going to keep digging into this. And the Tiffany kind, that is something that she and her family are going to have to chat about. Because the genuine stress of her parents, I can't even imagine. So that I feel for them. They did bring in the FBI and the Secret Service, but law enforcement has also said that they need more answers from her. So, Diana, if she did, the biggest consequence is really going to be whether or not they charge her, and they could charge her civilly, I suppose, for the restitution, for the amount of money spent on the searches. Or, a criminal false police report is generally a misdemeanor, and it could carry restitution for that. They could do a civil charge for restitution for the amount spent in the search. And we'll see if that happens. So hopefully we get to just see what other information comes out. So Lacey said, if you were the prosecutor, how would you handle this? I don't have enough information to tell you how I would handle it. I have a lot of questions. And I would want to know more before I decided anything. So based on what is publicly available, what would I want? More information. That's how I would handle it. I guess that's my answer. How would I handle this? I would ask for a lot more information, but I always want now in my coverage, and this is the same thing I really wanted as a prosecutor, I want most of my questions answered before I make a decision about anything, because I want to consider all possibilities. And that is the only way to consider all possibilities is to ask questions. So I have a lot more questions. Law enforcement said they have a lot more questions. So we'll see. Lori said, I heard last night that stealing anything over $30 is a felony. In Alabama, really? I'm sorry. I was a prosecutor in California where stealing anything under like $3,000 is like an infraction. So I don't know. I know that in the press conference, they said that she had taken some toilet paper and like a bathrobe from work, but there were searches with regard to taking money out of a cash register, and she had cash in her sock. So I don't know if there is a belief. There is a belief that she had taken money from her employer. If that is the case, I'm sure they will be able to figure it out. And she could end up charged. If she took money from work, she could end up charged with that. But I did not even look at the theft statutes in Alabama. Lauren said in Alabama it's 500, not 30. 30 seemed real low. This 500 to 650 is generally the range. But we will see. And if that's the case, again, there will be more information on this, and we will see. At the end of the day, I think a lot of people feel like I was rooting for you and this feels odd. And a lot of people were genuinely scared. And genuinely scared. People in the area were genuinely scared. So that, I think, is where some of the pressure on law enforcement came in, because the community was like, is there somebody running around grabbing women off the side of the road? Can you please let us know? And we saw that pressure in the Murdaugh case as well. After the murder of Maggie and Paul, We saw law enforcement rush to put out a statement that there was no danger to the general public, and that was used against them in trial, wasn't it? In trial, Jim and Dick turned around and were like, see, law enforcement already decided it was him. Already decided it was him because they said there was no danger to the general public. So with all of this, law nerds, thank you for being classy. Thank you for being compassionate. And we will see it unfold. There are lots of questions. There are lots of questions. I don't know if we'll get them answered, but there's a lot of questions about why. I don't know if we'll get those answers. So again, interested to see what Natalie Lawyer Chick has to say and whether she breaks it down. I did not spend a lot of time breaking down what could be charged, what couldn't be charged, because again, in my coverage, I generally wait and see with most cases, but no danger to the general public, strange Google searches, no evidence of a toddler. We will see what happens. So with all of that, it was, RK, watching her brother's plea was heartbreaking. It is. Her family was terrified. And they as a family unit are going to have to deal with that. And that is that's a level of broken trust that's going to be hard. And then again, they're not going to just get to deal with it themselves. They're going to deal with it with reporters camped outside, right? And that's not going to be, and the vitriol of the internet. And that's not going to be easy either. So we will see what happens from here. Again, excited to see Natalie Lawyer Chick's take. Joy said that brother was not her brother. I have not seen, again, this is why I'm always hesitant to share stuff. I have not seen reports of that. But again, I have not gone sleuthing into it because we have so much else to cover. So that, but I will take a look. Tinsley, good to see you. And this is why I adore you. My prayers that this doesn't discourage the public around real cases. It shouldn't. Again, it shouldn't, but it might, which is always a real concern. So many people go missing without this kind of national media attention, and this kind of national media attention can help. Someone who's a truck driver passing through the area was like, oh, I might have been in that area, and they can find, video footage that might help in a case. And the only way they're going to necessarily know that something had even happened is by this type of national media coverage. And I hope that that continues and we can use everyone's concern in a positive and productive way. But again, if it happens sometimes, it happens sometimes. And it's not new that it happens sometimes. We saw that with Sherry Papini. It's not new. It always makes me a bit sad if people feel like this is their only option. And that same with Sherry Papini. I still can't wrap my head around it. I don't know how that's the choice that you make. I don't know. So, Kaylee said we saw that in Pepito. Not Sherry Papini, Gabby Petito. A family camper had blog footage that led to her remains. Exactly. And I hope that continues to encourage people. Again, if you see something, to say something and hope. Oh, so, Nightbot, we got it. I liked JB's broadcast last night because he talked about that too, how people who don't get the publicity may feel. And that's true too. And that's hard for family members of people who are missing, who've been trying to raise the alarm for so long that they feel frustrated by the national media attention some cases get and other cases don't. So, with all of it, it's surprising. I don't know. Were you all relieved? I was very relieved when I saw the news that she had returned home. But then when they're like, she walked up and knocked on her front door, I'm like, in my little prosecutor brain, I'm like, that's unusual. And I think it's okay to ask questions. So let's continue on. I am then confused. I have questions. You have questions. We have questions. I imagine you can't really predict the level of national attention some stories will get and some stories won't get, right? And I don't know if you can ever know that. So I tend to come at things that, you know, trust, but verify. See what else comes out. And it was, Michelle said, an emotional roller coaster for sure. Yes. Yes. So again, we will see what happens. She is going to have to deal with the fact that her name and photo are forever tied to this story. Her family is going to have to deal with the terror that they felt, that she was, that they thought she had been abducted. They are going to have to deal with that within their family. And we will see what law enforcement chooses to do after this. So, we'll keep an eye on it, but this is going to impact her, probably for the rest of her life, whether or not law enforcement pursues charges, whether or not there are charges to pursue. I don't think you can underestimate, the impact something like this can have. So, Rachel said, I was relieved, but rather puzzled. And I think that's where a lot of people were. And I absolutely feel for her family. Absolutely feel for her family. And hopefully they will all be able to heal, because this, for her family, and I'm sure media is still camped outside of their house, that is going to be a very traumatic experience for them. So let's move on to Idaho, shall we? I think that I have said all that needs to be said more than once. And we will move on. Look, we're not going to stop talking about the way that technology can help when people go missing. But the thing that surprises me, I'm going to move on. Also me not moving on. Yep. The thing that will consistently surprise me is that people underestimate that your technology is going to tell on you no matter what. And we are going to see people's searches continue to come out. We saw it come out in Murdaugh. We saw it come out in Richens. We've seen it come out. Your technology will tell on you every single time. You are not more clever than your technology. Some of y'all might be more clever than law enforcement, but you are not more clever than the tech companies, because they want to monetize the things that you are searching for, and they are going to know. They have a reason to do it, but law enforcement can tap into that. Your searches are going to tell on you. So if you are searching luxury prisons for the rich or Taken the movie, the people are going to judge it at some point. Those might be 12 jury people that judge it, but people are going to judge it. Your technology will always tell on you, which is why we saw Jen Shah using burner phones, because Jen Shah knew that her technology was going to tell on her. So she had alternate phones, hoping that she could outsmart law enforcement, knowing that she couldn't outsmart technology. And you can listen to that on this season of Queen of the Con. Look at me. Look, I did a thing with a segue. Elizabeth bringing me back to reality and back on track. Back to life. Back to reality. Law and Lumber update. Let's talk about it. This is our second quick bit. That wasn't a very quick bit. That was a long bit. This is our second quick bit. That was a big bit. It was not a quick bit. It was not a short bit. It was a longer bit. In the podcast this week, I talked about Erika Girardi and Tom Girardi and other things. But one of the things I talked about was Erika Girardi's earrings, the scandal earrings. Hold on. I'm going to pull up my Twitter because I know it's there, and then we'll go from there. If y'all don't remember the scandal earrings, I'm going to show you the scandal earrings real quick. All right. We always make it back on track eventually. I think that's only because of the chat, though. Mary, I can't underestimate. The reason is because of the chat. We get back on track because of chat. Chat is bae. These are the scandal earrings, right? Wait, I made that too big. These are the scandal earrings. They are massive diamonds that Tom Girardi seemingly purchased with a check directly out of a client trust account. The scandal earrings were then gifted to Erika Girardi. She wore them throughout Real Housewives. It came out that during the bankruptcy proceedings that these earrings were purchased with client trust funds with a check written for $750,000 out of the client trust account to purchase these earrings. And then the earrings were like delivered in Vegas, blah, 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 blah. So the scandal earrings were then ordered by the bankruptcy court to be turned over to the bankruptcy trustee. Erika objected to it. You can go follow all of the motion breakdown because I covered all of it. The bankruptcy court ruled against Erika and said, turn over the earrings. The earrings were then turned over. And then after they were turned over, they were subsequently auctioned off for $250,000. The district court hearing the appeal on this determined that the bankruptcy trustee had not proven that the scandal earrings were the asset of the bankruptcy estate. So these earrings, they determined, were not properly an asset or not proven to be an asset of the bankruptcy estate. I broke that down on the podcast. But then there were lots of questions as, well, does Erika get the earrings back? Well, no. Kay Phillips in the chat said, why $750,000? I don't know. That's how much they charged for the earrings, and that's how much Tom Girardi wrote a check to pay for them. I don't know why. And I've got questions about that too. Did they pay the jeweler $750,000 for the earrings and the jeweler keep it? Was it a way that they were moving money? I don't know. I had questions about it too, because they only sold for about $250,000. I don't know. So, question. Do you have a picture of her wearing them? Yes, I do. Hold on. I do. I just didn't have it pulled up there. Yes, there's lots of images of the scandal earrings, and I'll pull up my documents on how big they are. They are multiple carats of multiple carats. So yes, there's lots of pictures of her wearing them because she wore them for the entire season of the Real Housewives, and all the other women are like, just give back the earrings, man. So this is Erika wearing the scandal earrings. So Erika turned over the earrings to the bankruptcy trustee. When Erika turned over the earrings to the bankruptcy trustee set them for auction. Let me just pull up. I've got the gemology certificates on these. Let me just pull it up. Let me just answer all the questions. Just answer all the questions about the earrings, because there was a whole damn lawsuit over the earrings within the bankruptcy. So when Erika turned over the earrings, she objected to turning over the earrings, but did not move for a stay of the proceedings and of the auction. She did not ask that the auction not go forward. She did not ask about any of that. So these are 6.5-ish carats each. So they were like 10 by 10 earrings. So hopefully that helps as I pull up the certificate really quickly. So this is what the jeweler slip said for M&M Jewelry. These were to Tom Girardi, 2007. Ladies handcrafted 18 karat gold, white round, brilliant cut diamonds, micro pave set stud earrings. So there's diamonds on the prongs of those. The princess cut diamonds weigh 7.09 carats and 7.7 carats. Grade, VVS, whatever, clarity and color. And then they have the GIA certificate number. Here's what happened when total $750,000. Here's the problem. The GIA numbers and the carats don't match the things that the bankruptcy trustee had. So when we go forward in all of this, there's lots of questions about the earrings, but that's kind of a side issue because 7.09 carats and 6.5 carats are very different. And when you pull up the gemology certificate numbers here, the gemology certificate numbers don't match the weights depicted. It's very confusing. That aside, because I went down that road for an entire live stream. So did Rob. Rob and I both were just like, these don't match. Why don't they match? And why is everybody fine with it? Like, either way, they sold at auction. I still have questions about the earrings, about whether the earrings that were turned over to the bankruptcy trustee and the earrings in that receipt are the same. It says princess cut. So I have questions about what is on this receipt and what was turned over. I don't know if we'll ever get the answer to that, but whatever. So Erika said, I don't want to turn them over. And it blew up when they were in Aspen, along with like Tequila Gate. It blew up when they were in Aspen. And everybody's like, just give the earrings back. He wrote the check out of a client trust account. Like, we've seen the check. It's in the court filings. $750,000 to this jeweler. And Erika's like, because legal reasons. So Erika's attorneys fought, saying, hey, we don't think these earrings are proper property of the estate. We think even if you determine they're property of the estate, they encompassed his legal fees that hadn't been taken out of the account yet and all this other stuff, accounting stuff. And then this went up to the district court out of the bankruptcy court to determine whether the ruling was proper. And what the district court decided back in May was that no, the ruling was not proper, that the earrings were not proven to be assets of the estate. And so they remanded it down back to the bankruptcy court to deal with it. Like, hey, go sort it out. So Erika wins on that appeal because it gets reversed. Erika could have lost. The court could have said, no, these are estate property. Too bad, so sad, whatever. This gets reversed to be dealt with for further proceedings. So now the further proceedings, we haven't seen any filings in the bankruptcy court since May. It is July 20th. I don't know if they are trying to settle this behind the scenes. I don't know if they are trying to determine if they need to turn over the $250,000 to Erika. I don't know if the trustee wants to litigate this again and see if they can meet the burden to show that the earrings were estate property. Either way, the sale is final and the earrings are not, like, they're not yoinking the earrings from the purchaser and giving the earrings back to Erika. They're going to have to make it right somehow, but I have no idea how they're going to try to do that because we have not seen any filings about that, which I have questions about. So Rob from Lawn Lumber, who is a bankruptcy attorney, I reached out to Rob. I should have reached out to Rob before, but I didn't. I should have reached out to Rob before, but I didn't. And reached out afterwards. I was like, hey, this is really, really surprising. So Rob talked about it on his Twitter yesterday. Let me pull this up. And said, no, this doesn't mean Erika gets the earrings back. A lot of questions about that, but I put this up as I was streaming the premiere. So I was like in the premiere chat. A lot of people said, people were saying that the earrings go back to her. The earrings don't go back to her. Bankruptcy law protects good faith purchasers. Erika didn't seek a stay of the auction pending appeal and can't now challenge the sale itself. Correct. She has a claim to recover the fair market value of the sale price from the estate. So does Erika get back the $250,000 they were purchased for? Does that go back to her in cash? Why did Erika's attorneys choose not to ask for a stay and get the earrings back? It raises a lot of room for conspiracy speculation. Is it because she wants the money? Is it because this was a PR issue? Is it because the earrings don't seem to match the certificate in the first place and they wanted the bankruptcy trustee to have to deal with selling them because the receipt and the gemology certificates aren't the same? Did they just want that to get, dealt with through the bankruptcy? Who knows? But they were sold for $250,000. Can Erika get that money back from the bankruptcy trustee? Possibly. Could they be trying to settle that? Possibly. Could the clients in the Resilin action be like, Okay, hey, but that $250,000 was supposed to be in our client trust account and it didn't get distributed to us. It really depends on whether or not attorney's fees had come out of that trust account and cost had come out first or not. There is so much shit surrounding this that is very difficult to parse. I just want the parties to file their motions so I can see what they think. It's like, could be this, could be this, could be this, could be this, could be this. But can somebody just tell us? I still think that the reason Erika was fighting over these earrings, because it's not a good look on the show. They're like, these earrings came from victims, give them back. And what I think Erika can't say on the show is, I still have to deal with the fucking IRS and the franchise tax board that's not going to get paid out of this bankruptcy that she is still going to be liable for. So do I think her lawyers are advising her to hold on to assets that she can use down the road when the tax consequences come down? Yes. Yes, I do. That's exactly what I think they're doing. Is that me speculating as an attorney? Yes. Would that make the most sense? Because attorneys aren't thinking PR. Her attorney is not being like, I don't know, man. Is Kyle going to give you a hard time about this in Aspen? Attorneys are thinking about, you have a bunch of shit to pay. And we can foresee the potential liability here. Because if Tom was stealing this much money from clients and Tom is the one doing the taxes, but Erika is also signing the taxes, which she has said in her book that she was signing, she is on the hook for other stuff that is going to fall at some point. We've already seen the IRS say in the bankruptcy that they are owed millions, and we've seen the franchise tax board say that they are owed millions, and they're probably not done digging yet. So there is a real tax liability hanging over her head. Scorpion said, Emily, can you explain what the franchise tax board is? Yes, it's California's tax entity. Some states have different tax entities. So the federal, the IRS is the federal one. California has its own. The franchise tax board deals with California taxes. So we are dealing potentially with tens of millions potentially of dollars in potential tax liability or potential tax litigation, depending what the IRS decides to do. Because what do you know because you are law nerds? Tell me what you know because you are law nerds. The IRS will get theirs. The IRS just added like 90,000 more agents to go after PPP loan fraud and all the other stuff. The IRS will get theirs. And if you follow the money, if you're the lawyers, your job is to protect your client, not protect their reputation, to protect your client from criminal prosecution, civil liability. And for Erika, the strategic play legally is to hold on to as many assets as you can hold on to pay off the liability that is going to follow you. Because in the personal bankruptcy of Tom Girardi, they are not discharging the bankruptcy. So any debts that are left, that are debts accumulated in their marriage, she is going to have a crater of those debts to deal with going forward on top of any potential tax liability. So her attorney is likely thinking, hold on to the assets to get paid, right? To pay all of the other things that are going to come down the road. A PR person might have a conversation about whether or not once these things are filed in public, there is a strategy to deal with this different than the legal strategy. But even if these are worth $250,000, that goes a long way to starting to settle potential liabilities down the road, especially seeing that Erika's getting no money out of Tom Girardi. Everything's in the bankruptcy. The house, the property, the everything except like whatever she makes on Real Housewives and whatever she's able to make herself from, I think she has hair extensions. She's going on tour. Those are assets that she's going to have to hold on to pay not just the lawyers, but any potential liability down the road. And this is hundreds of thousands of dollars of litigation because she has to litigate in the bankruptcy. She has to litigate the civil cases where she's being sued, and there are numerous civil cases where she's being sued. And she has to still film a TV show because that's how she's making money. So then she still has to subject herself to the public scrutiny so that she can actually continue to go on and pay for her life. So again, PR strategy, legal strategy. Here it seems the legal strategy is overriding. And that's what it is. I saw a question in the court saying, Hey, Nishay, if Tom dies, does that change Erika's liability? No, they're marital debts. So she is going to be stuck with a cavern of marital debts. But the earrings, she might be getting some money back for because they've been sold. So that's what it is. But no, the earrings don't go back to Erika. Again, they're not pulling them out of somebody else's ear and handing them back to Erika on a Brinks truck. It will be the money. So that's what it is. Shall we move on to Idaho? Chad, are you ready to go to Idaho? Are you ready to hop a road trip or a plane, depending on where you live? Are you ready? So, are you ready to go? I think so. Let's see. Shall we? Everybody's like, I'm ready. Somebody S. Moore volunteered for earring pickup. That's funny. All right. Bags are packed. Let's road trip. Let's pick up some, like, I don't know, some tahini peanuts and let's go. All right. Idaho. There is lots to cover today. There are new filings in the criminal proceeding and a lot of new filings in the civil case. So let's go to the criminal proceedings first because there are less filings there. And then what? 503 error. Why is this website 503ing on me? We're going to have to go the other way. I normally just pull them directly from the website, and the website is down. Are you updating it? Are there more documents? What are you doing? Idaho, what are you doing? You're making me nervous. Let me try one more time. It's been doing that all day. Server's down. All right, y'all. Rude. All right. I'm pretty sure I fingers crossed. I'm pretty sure I downloaded these yesterday. Me. Don't rely on the interwebs. Let's see. Did I? Oh, I might not have. Might not have downloaded all of them. Oh, wait. There's the motion for scheduling order. We're going to cover that. Fingers crossed. Fingers crossed. There's the motion for hearing. There's the reconsidering order. Where is it? Where is it? I need it. I need it. Thank you. Thank you. I actually did download them, so I can't even facetiously say we are professionals. It's like, we did it. We did. We handled the minimum, y'all. We handled it. We handled it. Is that, you scared the crap out of me, Dr. B. My husband scared me. You scared me.
It's because you were so loud out there, you didn't even hear me coming in.
I am loud.
Yeah, that's why I'm closing the curtain.
My soul has left my body because Dr. B scared the ever-living crap out of me. He's like, you're being so loud. I'm like, I get animated. Look, we have to amuse ourselves. The chat says hi, Dr. B.
Hello.
It's been that kind of a day. All right. Thanks, babe. Motion to reconsider order staying time for speedy trial. This is the prosecution objecting to the court granting the defense an extra 37 days here. Previously in Idaho, the court had granted the defense an extra 37 days without deeming that the defense had waived their right to speedy trial. The right to speedy trial means from the time that you are indicted on the information or held on the information to trial, you have 6 months. 6 months. If you are not brought to trial within that time, the case gets dismissed. Though the prosecution can bring it one more time. They have like one more bite at the apple, but 6 months is what it is. In this case, the court said, we're going to give you an extra 37-day stay. The defense moved for a stay with regard to the grand jury indictment, the seating and impaneling of the grand jury, saying we didn't have enough time. We haven't timely gotten the grand jury information. We have motions we want to make about the seating of the grand jury. We want to go and deal with that. We need more time. So the defense asked for a stay so that time gets paused so that the 6 months just gets embiggened. It's just like 6 months really means 6 months plus 37 days at this point. But we haven't waived the right to speedy trial. Once you waive the right to speedy trial and the prosecution's like, hey, Your Honor, we've got a detective on vacation, we need to put the trial out, then they'll be like, okay, we can put the trial out. Once the speedy trial right is waived, these cases can take forever. Because if there's an issue with a witness, then it can get continued. If there's good cause to continue, if a prosecutor gets sick, they can continue it. When you're in the speedy trial right, there are a lot more restraints on what can be done. And the only one who can go past that 6 month period is the defendant if they waive the speedy trial right. So the prosecution is like, hey, boo, you can't have it like the case isn't really stayed. So they're objecting to the stay. Comes now the state of Idaho through the prosecutors to request that the court reconsider the order staying time for speedy trial. Motions to reconsider don't often go well. For those of you that are parents, for those of you that have been raised by parents, how does it ever go when somebody's like, this is the answer, and you're like, okay, so I hear that that's the answer, but can we reevaluate that and maybe make that not the answer? Like, can you please change your mind? And as humans, what do we know about humans? Humans don't love changing their minds, right? Especially when you've like made a ruling on the record. Judges don't often reconsider themselves. This is exact, but mom, still no. But what about still no? But what about still no? I would say it's a little like when I say ask your father. I think that's more like go to the appeals court, but only if they have the authority to override your decision. This is more like them just asking you again repeatedly. It's like, but could you do this? But could you do this? But could you do this? This is a real apropos question. Toya said, how much would Dr. B spend on earrings? I think $70 would probably be his threshold. Maybe 100. But also, Dr. B doesn't tend to buy jewelry. He tends to acquiesce to the purchases that I make. So this is more like being asked to change your mind a million times a day. So, let's see. Question, is the motion to reconsider required before going up to appeals? No. I don't think so. And I don't think this will go up to appeal. I don't think there's an abuse of discretion here. I don't think they want to waste their time appealing it. I think they're just asking the court, but can you consider it this way? All right. Respectfully request this court reconsider its order. Your Honor, can you please change your mind? The law does not allow defendant to partially waive his statutory right to a speedy trial, and thus his acquiescence to the limited stay in this matter could be deemed a full waiver of speedy trial. So the prosecution might be trying to protect the record or kind of wave the red flag and be like, so I see what we've done here. I've never seen a stay implemented in a criminal case. There's either a waiver of speedy trial or not. There's no like, kind of. And the limited scope that was put before the court was that there could be a stay if the grand jury was not seated properly, but that determination had to be found. So I was surprised because the court was like, I kind of find good cause for it, but the court didn't find it under the one really narrow statute that allows for it. So I was kind of confused. So I understand why the prosecution is like, excuse me, sir, but you can't though. So let's see what the prosecution has to say about, but you can't though. The court stay has no practical effect where A, the parties are continuing to litigate discovery matters and file motions, B, trial remains set, and C, the defendant is free to request a stay in the future. Because at this point, the speedy trial clock is 6 months plus 37 days, but they didn't extend the trial. Due to these practical considerations, the state respectfully requests that the court rescind its order staying time. Because at this point, even though there is a motion to stay time, it's had no practical effect because they haven't extended time past the 6 months. They haven't gone to like 6 months plus a day, 6 months plus 10 days or whatever. We're not there yet. The 6 month period hasn't run. It runs sometime in November. So we haven't gotten into December where we've used those extra 37 days so you could actually rescind it. The court could rescind it. Whether they will, I don't think so. Courts don't like to rethink themselves, but you never know. The state further requests that the jury trial in this matter remain set for October 2nd. Y'all are bold. Or alternatively, that it is moved beyond the speedy trial period only if defendant unambiguously waives his right to speedy trial. And the defendant at this point has unambiguously said, I am not waiving my trial right, but I do want to stay. But I'm not waiving my trial right. Over and over and over again. The state makes these requests given that the parties, the state makes these requests to give the parties, the victims' families, and the witnesses predictability. Sir, prosecutor, this is a criminal case on a first setting on a quadruple homicide. I love the optimism that this is going to go to trial on the first trial date setting. Okay. There is never predictability. It is one of the hardest things about criminal trials is you will go and subpoena literally everyone in God, and then a day before trial, or the day you're supposed to start picking a jury, you will be frantically making phone calls being like, so the case has gotten continued. Yes, I know you've already taken time of work. Yes, I understand that this is very inconvenient, and you spend like 3 days doing that. It is a feature of criminal practice that is ever present. Predictability. The only thing you can really predict is that things will get continued. Maybe it's different in Idaho. It is a smaller jurisdiction. Who knows? Predictability as to future trial dates to protect the record. I think that's a big point of it, and to avoid needless speedy trial litigation down the road. Right, because if they don't bring him to trial within 6 months, would Kohberger then say, well, dismiss the case. You didn't bring me to trial within 6 months. Though the court said in their order that Kohberger had agreed that he could not litigate this later. Background. Defendant was indicted on 4 counts of first-degree murder and 1 count of burglary. On May 19th, defendant filed motions requesting grand jury materials, including the record and transcript. In the days and weeks that followed, the state and defense conferred but were unable to reach an agreement on the scope of the grand jury materials subject to release under Idaho criminal rules. On June 13th, the defendant filed a motion to stay proceedings, arguing that he, quote, intends to contest the indictment, and asked the court to stay this case so he could discover the grounds upon which to do so. The sole legal basis offered by defendant in his request to stay was Idaho Code 2-213, which allows a party to request to stay in proceedings where there has been, quote, a substantial failure to comply with the applicable law in selecting the grand or trial jury. It seems to be a very, very, very narrow circumstance. Substantial failure to comply with law in selecting the grand jury. But we've gone over this over and over and over again, and it seems from that section and the motions that this can only be done after the defense has made that showing that there was a substantial failure to comply in selecting the grand or the trial jury. You can't put the stay in to discover the grounds to then ask for the stay. Like, you don't get more time to ask for more time. Hopefully that makes sense. On July 10th, the court issued an order for a limited stay of proceedings. The court rejected the defendant's rationale that 2-213 applies at this stage, which we all agree with. Nevertheless, the court elected to issue a limited stay to toll the trial period for 37 days, relying upon good cause, found in Idaho Code 19-3501. As the court noted in its order for a limited stay of proceedings, Kohberger and his counsel agreed to the terms of this stay on July 6, 2023, acknowledging that he could not later argue that his right to speedy trial was violated so long as it was brought to trial within 6 months plus 37 days. I should have just kept reading. I said that. Trial remains set to begin October 2nd. Watch this trial just go to trial October 2nd. Just all of us being like, there's no way this trial is starting this year. And they're like, haha, it is though. Argument. Idaho Code 19-3501 allows the court to dismiss a case for lack of speedy trial is triggered, quote, if a defendant whose trial has not been postponed upon his application is not brought to trial within 6 months from the filing of an indictment or information. Notably, 19-3501 does not require an unequivocal on the record waiver of speedy trial. Instead, the statute's language excludes from relief those individuals whose trials have been postponed upon their own application. Well, that's a problem, a potential problem to the defense. Because I see the prosecution's point, or what the thing I think that will be their point. Asking for the stay is the defendant's own application. The defendant has asked the court for a stay. So instead of saying in the code there needs to be an unequivocal waiver of the right to speedy trial, they are saying that the code says, no, if the trial was postponed upon the defendant's application, which has now happened, there's a 37-day postponement, and he asked for it, then arguably that could be a waiver of speedy trial. They cite State v. Lundquist, stating that the Idaho Supreme Court held an individual who requested a single trial continuance beyond the speedy trial period in order to substitute counsel, which happens all the time, but objected to further continuances, had fully waived his right to speedy trial. Once you waive the right to speedy trial, even if someone says, but I just waived it for like 2 months to have a new counsel ready to go, it doesn't matter. Once it is waived, it can be continued beyond that, and it can be continued over the defendant's objection. So Island Thrifts asked in the chat, what is the benefit of not waiving this? If you waive and are like, my lawyers need another month to be ready for trial, and then the prosecution's like, well, we have witnesses on vacation. Okay, we'll put it out another 2 months or another 3 months. You lose control of the timing, because then the case can be continued over the defendant's objection because the defendant has waived the right to speedy trial. You've got that 6-month window. And after that, you wait to go to trial. And that could be 2 months. That could be 6 months. That could be a year. That could be more. It happened so long, particularly during COVID, that these things just trailed on forever. Gringa Latina in the chat said, if speedy is waived, does it become open-ended? Yes, there's no more time period because the time period's been waived. On and on and on. All the chat that's saying CIE, the Sarah Boone case. Yes. Sarah Boone waived time for trial and has been screaming at the court via letter saying, why aren't you bringing me to trial? And the court's like, we'll get there. And she has been sitting for years waiting to come to trial and saying, we need to go to trial. And then there was a new attorney, and then the attorney wasn't ready. Her attorney could come in and say, my client wants to go to trial tomorrow. I'm not ready. And the court goes, good cause. She's already waived speedy trial. The prosecution could come in and say, hey, we need to do this. Speedy trial is waived. So once the speedy trial right gets waived, it can get continued over the defendant's objection, on and on and on. So this case, the circumstance is that the defendant waived speedy trial for one continuance and said, that's it. I'm waiving it for one. However, once you waive it for one, you're done. Emily Burgess, I'm not familiar with that case. Burgos sat in jail for 5 years because he waived. It can happen. It can go on. She's on her 7th lawyer. I mean, there's that too. How or why the defendant can benefit from waiving speedy trial. If their lawyers truly need more time, if they need to find witnesses, if their lawyers really can't bring it to trial in time, then sometimes they need to waive time. So this person had waived one continuance. Like, I waived my speedy trial right till this date, but no more. It doesn't matter. Because the court found that they had fully waived their right to speedy trial. The arraignment took place on January 4th, 1996. Jury trial was set for July 9th, 1996. On April 18th, 1996, Lundquist filed a motion to separate his trial from 2 co-defendants. The motion was granted on May 31st because Lundquist had not waived his right to speedy trial while the co-defendants had, which happened in the other case that's been going on in Idaho, There are so many names in my brain today. Y'all know what I mean. They separated the two because one waived speedy trial and one didn't. Valo Dayball, that case. They separated the defendants. One didn't. One waived, one didn't. Because if one's not waiving, you can't force them to go to trial with their co-defendants, which also can be strategic. If you don't want to go to trial with your co-defendants, that can be a strategic choice. And for lawyers, sometimes a really good strategic choice. And we saw argument of that on Tuesday. Not in a criminal case, but like get us away from each other. Get the two defendants away from each other. Sometimes that's really good for co-defendants because then they have kind of the empty chair defense. It's like, it's not my fault. It's that person's fault. And that person's not in trial saying it's not my fault. It's their fault. On June 14th, Lundquist moved to substitute a new attorney for one of his two defense attorneys representing him. The court determined that Lundquist would be allowed to substitute counsel if he agreed to a continuance of his trial and waived speedy trial right. Lundquist and his counsel had concerns that he could be tried with his co-defendants in the future if he were to waive his speedy trial right. I feel a sense of foreboding and foreshadowing. However, the court noted that the co-defendants were not prepared to proceed to trial and had requested a trial continuance to January 97. Whereas the court could set Lundquist's trial earlier in August or September. Lundquist agreed to the continuance and waived his right to speedy trial. His trial date was continued to September. On August 5th, the state moved to continue the trial in order to prepare a response to a report from the defense psychologist. The defendant objected to the continuance, arguing that the state had time to prepare. He'd already waived his speedy trial right. Lundquist offered not to call the psychologist if it meant there would be a continuance. He really didn't want to go trial with his co-defendants. Nevertheless, the court granted the state's request to continue and set the trial for January 8th, 1997. Right back where you started, because again, once you waive the right, it's gone. On August 8th, 1996, the state made a motion to consolidate the case with the co-defendants, and that motion was granted. That kind of sucks. Like, I don't know. The state might have had a compelling reason that they really wanted these defendants tried together. But if he's like, look, if you need more time to prepare or respond to the psychologist and we just won't call the psychologist, the court could have said that's a solution. He won't call the psychologist. Instead, this defendant ended up with exactly what he was trying to avoid. Ultimately, Lundquist's trial did not start till January 29th, 1997, a year and 25 days after he was arraigned. On appeal, he did not contest the continuance from July to September. Instead, he argued the subsequent continuance, that the January trial date was a violation of his right to speedy trial because the waiver was limited. You can't limit that waiver. There's no halvesies. The Idaho Supreme Court unambiguously rejected the notion that a defendant can partially but not fully waive his right to speedy trial, explaining Section 193501 does not allow for a limited waiver. Once the trial's been postponed, the 6-month statutory period no longer applies. And that's what it is, right? In this case, the court issued its order for stay after defendant requested a stay under Idaho Code 2-213, which, as the court noted in its order staying time for speedy trial, is a premature request. Instead of issuing an order to stay under Idaho Code 2-213, the court crafted a limited stay that serves not to halt the proceedings in the traditional sense of a stay, but rather to simply extend the speedy trial period for 37 days. However, trial was left set for October 2nd. I see why the state is like, this is a potential problem. Because it's not a traditional stay. A traditional stay means everything freezes. A traditional stay is like when, I'm declaring bankruptcy and everything stays. When you go into a stay period, everything stops. Discovery stops. The entire case stopped. It's what happened with the Murdaugh insurance case when he went to the murder case. They stayed that proceeding, meaning nothing happened in that proceeding. No discovery, no tolling of statutes, no motion. It froze. It absolutely stopped. And then the murder case happened. And then they resumed after the murder case. That's a traditional stay. Everything literally, stop right there. Thank you very much. It stops everything. And the prosecution's arguing this does not halt the proceedings. It's not a real stay. You're not freezing things. You just extended the right to speedy trial for 37 days, which seems like a partial waiver of the right to speedy trial. I actually understand their argument here. I don't know what the court's going to do on it, but I understand their concern. Although defendant may have stated on the record that he did not intend to waive speedy trial, the practical effect of his motion for stay in the court's subsequent order is that the court has issued an order upon the defendant's application that the trial may be set outside the 6-month speedy trial period. They're like, but it's happened. But it's happened. And that's their argument. I'm interested what the defense is going to say about this. The prosecution has concerns. I think they're preserving the record. I don't know if it's going to matter. They say as a purely practical matter, the parties, witnesses, and victim family members are now in limbo. Will the trial be set out 30 days upon the defendant's option or not? I mean, that happens. That happens. Yeah, chat. I know my chat froze too. I don't know. Are we glitching the YouTube today? I mean, there's 8,000 of us here. We've handled more. It shouldn't be glitching. I don't know why it is. Sorry if y'all are having chat issues. So that's frustrating. So as a purely practical matter, everyone's in limbo. Well, that happens in criminal cases. I get them. If the defendant reviews the grand jury materials and elects to challenge them, the court will issue another few weeks postponement. Or will the court issue another few weeks postponement? Could a few more week postponements be forthcoming? This is part of trial practice. I get it. I get it, but it's frustrating, but it happens. The state is respectful of the defendant's responsibility and need to prepare for trial, and specifically the need to review all the materials at issue, but it is the state who carries the burden of proof in this case. The chat is saying my Spice Girls broke the internet. It was that bad, huh? I mean, it might have been that bad. Apologies to all of your ears. But it is the state who carries the burden of proof, an awesome endeavor requiring the subpoenaing, preparation, and coordination of numerous witnesses. Yes, it's a fuck ton of work, many of whom require travel arrangements, also a fuck ton of work, and other logistical considerations. Yes. However, these witnesses include loved ones and friends of the victims who are undoubtedly anxious for some degree of predictability. Yes. However, I think they led with their strongest argument. Their strongest argument is that the statute says upon the application of the defendant, and it seems here that the court has extended the speedy trial period upon the application of the defendant. And I think that's a very real consideration that the court's going to need to address, and at least the record's preserved. The thing is, if he's acquitted, the state can't do anything about this, and the state can't force the speedy trial period to not be extended. If the defendant says I need more time, then the defendant can force the trial out. The defendant could do that the day trial starts. The judge would be pissed about it. But if there's good cause, the defendant could show up with jurors sitting in the veneer, with hundreds of people subpoenaed, with hundreds of jurors subpoenaed for jury services, and say, we need more time. And generally, the court is going to have to grant it, except in very, very limited circumstances. That unpredictability happens. The state is appreciative of the balancing the court must do in this case and of the court's sensitivity to the needs of the parties, but while the defendant undeniably has the right to review the grand jury materials, the law simply does not allow the defendant to agree to toll speedy trial beyond 6 months and later invoke his right to a speedy trial. So the prosecution has filed a motion, Your Honor, you cannot have your cake and eat it too. You either do not waive your right to speedy trial or you do waive your right to speedy trial, but there's no halvesies. I'm interested to see what the court will do. I don't know if the prosecution would take that up on appeal. I don't know when that's going to be heard. We've got a couple hearings coming up in Idaho. We've got motion hearings coming up, and an evidentiary hearing coming up. I think that's going to deal with the DNA stuff. So we've got those things coming up, and the prosecution is still fighting over the DNA. Let's look at the scheduling order, and then we're going to go to defamation, or the defamation case, I should say. We're not going to we're just going to casually move on to some defamation. Now we're going to go over to the Idaho defamation case next. Motion for scheduling order. This is again the prosecution. The prosecution is like, you want a trial within 6 months? Let's do it. Let's go. Let's go. Comes now the state of Idaho through the prosecuting attorney, seeking a scheduling order. Deadlines for completion of discovery. Deadlines for both parties to make expert disclosures. What is this, a civil case? The prosecution is like, can we go, please? Deadlines for filings on pretrial motions and responses and replies thereto, including but not limited to motions in limine, motions related to the death penalty, and motions under ICR 12B, deadlines for jury questionnaires proposal, deadline for proposed jury instructions, deadline for witnesses pursuant to ICR 16B6 and C3, deadlines for Rule 404 notices, 404B notices. Do they think the defense is going to have Rule 404B notices? Interesting. Dates for pretrial motions to be heard, any other matters to facilitate the orderly process. Well, the only date we really have that we know is 4 days. The defense has to turn, by July 24th, the defense has to turn over their notice of alibi to the prosecution. I wonder if there's more motions. Like, why is the website down today? I will keep checking it throughout the stream to see if it comes back, but we are going to move on to the TikTok defamation case. And then if there's more motions, we will see. I see you guys asking about 404B notices. It is 404B deals with character evidence. The prosecution, every state statute has a different amount of time when you have to turn over 404B. So they're asking the court to clarify. Normally, the defense is not turning over 404B evidence, but it is, if you are going to bring in witnesses of character, they might do it with regard to some of the surviving roommate witnesses or want to. So they're going to have to give notice of that. And if the prosecution is going to use 404B against Koberger, there's time when they have to do that. All right, I need to pull up the other file. I'm going to swoop-a-doop, and we're going to give a brief summary. Swoop. So, in Idaho, we are covering the TikTok defamation case. The TikTok defamation case is a TikTok creator who has accused a professor at the university of committing these murders and has doubled and tripled down. The TikToker is representing themselves in federal court on this defamation case. It has been interesting. They have doubled down. The TikToker has said that they are a spiritual witness to the murders through their gifts. And then instead of just countersuing or trying to countersue, the TikToker representing themselves, trying to countersue the professor at the university, because we've gone by professor and TikToker, the TikToker decided to sue the professor and all of the lawyers. And the lawyers are like, yo, you can't do that. You can't do that at all. What you can't do. So this is a disaster of a case because it's just a mess. It's wild. It's absolutely wild. And I try to stick with wild because it's, again, without speculating on anyone's mental health, this is a strange result. And so I stick with wild. This is wild. The behavior is wild and unpredictable. The filings are wild. It is wild. It is the professor's lawyers have called it a clout circus. It's wild. That is the word I try to use when I lose everything else. Because it is something. So there has been a lot that has happened since we last checked in on this case. The last time I checked in on this case, we had just gotten to the TikToker responding. I feel like I'm at the like last time on defamation in Idaho, the TikToker had responded to the professor's motion to dismiss. It was a 31-page response that largely reiterated what was already filed in their answer. This is after the court had already admonished the TikToker that they must adhere to the rules of evidence, the local rules and the rules of court. And the TikToker agreed because the case had initially been defaulted because the TikToker had failed to respond in a timely fashion. So that happened on June 27th. On June 29th, the court made 2 docket entries. The first docket entry was striking from the record the defendant's response to the motion to dismiss, the TikToker's response to the motion to dismiss, as it exceeded the page limits outlined in the local rules. So the court was like, no, you can't. No, you can't. Stricken from the record. This doesn't count. Go back and file it again. The response must be filed by July 6th, the proper one, and the reply in support of the motion is due by July 20th. On the 29th, same day these docket entries were issued, the defendant filed a new response, but instead of it being 31 pages in length, it is now 20 pages in length. I am very curious to see, and we're going to skim this real quick because so much of it has just reiterated itself over and over and over again. We're going to skim this to see if the TikToker just cut off the end and was like, oh, and just like yeeted 10 pages of their motion, or if they actually redid the motion. I don't know. We're going to look together real quick. Introduction. Comes now counterclaimant, TikToker, in opposition of counter-defendant, professor. The motion to dismiss the counterclaims. Pursuant to Campbell versus Wells Fargo Bank, it is the standard that specifically when deciding FRCP 12b6 motion, the court assumes, by the way, if you're going to say Federal Rules of Civil Procedure, you don't also have to say FRCP. The court assumes all factual allegations contained in the complaint to be true, giving the claimant to include counterclaimant TikToker the full benefit of the doubt. I mean, that's generally the standard. The background, again, is the same. It completely doubles down on the allegations made that landed us here in the defamation case in the first place. The legal standard has been set out very plainly. Argument. The claims are legally merited, pled with particularity, and met the legal requirement intended. That's it. That's the argument. Okay. Counterclaims. And then she gets into the counterclaims, but has learned what incorporating by reference is. See? She's paying attention. TikToker is paying attention to the other filings in this case very well. Incorporates by reference the other docketed items. So, Your Honor, just incorporate the rest of it so I don't exceed the paid limit. Fine. So then goes on to argue the counterclaims the way that we've seen before. It seems that this has been greatly truncated, that the amount of restating things has been tampered down to get us within that page limit. And again, we have read this now like 5 times, 9 times. We've read this a million times, so we're not going to go through it again. But it seems that they have shrunk their arguments by deleting particular sentences, but still tried to get it all in there. Let's see. We've gotten to the 11th. Arguments against that. It seems like all of the same outline of the arguments are there, but it is just squished into 20 pages. Conclusion. Request the court deny the motion to dismiss. Okay. So then, what happens next? So then the defendant responded to the motion to quash the summons the next day. The motion to quash the summons is fighting over serving the lawyers for the professor. And the professor was like, we are not proper parties. You cannot file this on us. So the TikToker filed a motion to quash the summons. Normally we wouldn't go through a motion to quash the summons, but it has some email conversations attached. And you know how I feel about an email that's attached as an exhibit. We just love it the most. So we haven't covered this yet. Let's go through it. Let's go through it. Oh, I made that too big. In smallin, in biggin, in smallin, in biggin. Introduction. TikToker filed 11 counterclaims in her answer to the complaint, adding attorney Olson, Watkins, Carone as third-party defendants. Here's the problem with that whole sentence. If it's a counterclaim, you can't add other people. Oh, sorry. Thanks, chat. If it's a counterclaim, you can't add other people. Michael Sharp, thank you for the super chat. I reached out to the attorneys just to verify it was the right GoFundMe. I think that it is, but I have not verified it independently. So I have seen that, but I wanted to wait. I emailed the attorneys just to verify it. So if I get a response to that email during the show, I will let you know. If I get a response after the show, I will let you know. I haven't verified it myself yet. I try to verify those things myself. So thank you. I have seen that. I always ask on a GoFundMe, so I had asked for clarification. We might get that by the end of today. We've got a lot more motions to cover. So here's the problem. A counterclaim means that party A sued party B, and then party B sues party A, or party A, B, C, and D sues party E, F, G, and then parties E, F, G sue A, B, C, D. It is the same parties suing each other within the same lawsuit. A snake eating its tail. But what you can't do is improperly join other parties. Cardi B sues Cardi A. That's funny as fuck. Yes, Cardi A sues Cardi B. No, Cardi B sues Cardi A, and then Cardi A sues Cardi B. That was with a swiftness, chat. When I say y'all are funny as hell, y'all are funny as hell. And I love you for it. Thank you. Can EF sue A, B, C, D without G? If A, B, and A, B, C, and D sue E, F, G, could E and F sue A, B, C, D without G? Yes, they could. It can be some, but cannot be all. So that felt like such a ridiculous hypothetical that should be on a bar exam. Speaking of which, the bar exam is coming up. And I've seen people studying for the bar exam on social media and such, but the bar exam is coming up. And as I was going through the Girardi bankruptcy stuff, the first thought I had when I was like trying to break down, my husband's like, what's going on with these earrings? And I'm like, well, this is the ruling and this is the remand and these are the options. If that question came up on a bar exam, it might make me cry. I'm like, this is so deep into the weeds in bankruptcy. And it's so specific that it's like, are the funds commingled? Are they not commingled? But there's this glaringly obvious issue of the fact that the funds are written out of the client trust account. That's like this overriding, glaring, like red herring at the time when you're trying to decide all the bankruptcy stuff, but it's like screaming at you, but you can't take money out of client trust accounts. It's like, yes, but it's a bar exam question that would make bar takers cry. I feel the same way about everything going on in the Angelina Jolie, Brad Pitt winery suit. It also feels like a bar exam question that would make people cry. But anyway, let's continue on with it. This is a 1L question. These are not bar exam level questions. These are 1L hypotheticals. Counterclaimant and third-party plaintiff TikToker filed 11 counterclaims in her answer to complaint, adding parties. And every 1L would be like, you can't do that, bro. It's a counterclaim. You can't add parties. And then the 1L would feel like, look, I know things. It would be like that moment where Elle Woods is like, because you need like evidentiary support. It's like that moment where you're like, I am understanding. You can't do this. This you cannot do. All 11 counterclaims are supported by statute and are legally merited. You can't do that though. resulting from the concerted actions of professor and her attorneys that are outside the parameters of professional conduct. I like that the TikToker is an expert in professional responsibility, outside the provisions of judicial immunity, and outside the provisions of attorney immunity. Can we get back to when TikTok immunity was argued? I missed that. It was simpler days. Background. Beginning on November 24th, 2022, TikToker used her spiritual practice, psychic abilities, metaphysical tools, and investigative skills to uncover the motive and details that led to the murder of 4 University of Idaho students that were killed in Moscow, Idaho on November 13th, 2022. Her spiritual investigation. I told you, we are continuing down the road. Her spiritual investigation revealed that the professor planned, initiated, ordered, and executed the murder of the 4 University of Idaho students. I should say this is caveat, despite all evidence to the contrary and despite law enforcement saying that this is not the case. On December 8th, Tracy Horan, practice assistant for the law firm, emailed TikToker demand letters from attorney demanding, demand letters do that TikToker cease making defamatory statements about professor and remove defamatory TikTok videos. Quote unquote defamatory TikTok videos. That she believed that she did not make, On December 12th, I missed a line. On December 12th, TikToker responded to the demand letter by posting another TikTok video. I would just like to say that while I appreciate that content is content, and I appreciate that if you ever take out a cease and desist against a content creator, that content creator will turn it into content. Hi, I've done that. It's going to end up on the internet. However, that's not a response to a cease and desist. Responding to a cease and desist letter email from an attorney with a TikTok is not a response. It is content. To respond, you also have to respond. I wonder, I'm going to keep reading, but did she email the TikToks then to the law firm and be like, my response is this? Did she get a ukulele and say, this is my response to your cease and desist? I don't know. But responding, it's like when you text somebody and then they call you, it's like, I texted you. Why are you responding to my text with a phone call? I am caught off guard. We had agreed to the method of communication. If a lawyer sends you a cease and desist, creating content about it is not responding. It is a choice, but it is not responding. You have to respond by email or choose not to respond. One of the two. But posting TikTok videos is not an actual response, but okay. But she posted another TikTok stating that she believes she did not make any false statements about Rebecca Schofield, the professor, and did not have to follow their demands. On December 13th, 2022, TikToker posted another response to the demand letter on TikTok stating that the professor does not have a case for defamation against her. Posting a document explaining the substantial truth doctrine as a guide. Not a spiritual guide, a substantial truth doctrine as a guide. Despite not having a legal defamation claim against TikToker that meets the elements, she's using elements properly, plaintiff, professor, and her attorneys filed a frivolous defamation complaint against TikToker in the Federal District Court of the District of Idaho due to the diversity of citizenship and falsified damages of $75,000 or more. Those are the statutory claims. Together, they conspired to deprive TikToker of the freedom of speech, the freedom of spiritual practice. Oh, I forgot that there was an argument about, there was like an adjacent freedom of religion argument in this. The freedom of speech, the freedom of spiritual practice, and $2 million. Look, your religion can't be a defense to defamation. The statements they publish about TikToker in the lawsuit were false, fabricated to meet the elements of a defamation claim. In furtherance of the conspiracy to deprive TikToker of the rights and property to embarrass, humiliate, discredit, and harass her, attorney and professor published a multinational press release with multiple news outlets publishing false statements about TikToker. Attorney published false statements that TikToker made false... I need string. Attorney published false statements that TikToker made false statements about Professor... Wait, I got to read it again. Attorney published false statements that TikToker published false statements that Professor ordered the murder of 4 students, knowing they are false, for the purpose of using the community's pain and the tragic event for followers and profit. I feel like I'm on a merry-go-round. But the heart of the TikToker's defense seems to be, I'm not lying, they're lying by saying that I'm lying. Okay. That seems to be the heart of the thing. The statements that the attorney published were disseminated on multinational news channels, social media, blogs, and news websites. As a result, TikToker was harassed, targeted, and embarrassed publicly online, social media, through phone and email, nearly every day to current. This is exactly it. It's like a, nuh-uh, I know you are, but what am I? In furtherance of the conspiracy to deprive TikToker of her rights and property and to embarrass, humiliate, discredit, and harass her, attorneys mocked, denounced, and discriminated against TikToker's spiritual practice, requesting the court to join in the discrimination of spiritual beliefs and practices by issuing orders deeming it implausible. They're not... I disagree with that... I disagree with most of the characterizations, but I disagree with that characterizations in that they're not asking the court to deem it implausible that she was a spiritual witness to a homicide. They're asking the court to find that it's defamatory, suggesting that the professor committed or hired someone to commit a murder. Argument against attorneys not being proper parties to the action. Rule 14A1 of the FRCP, a defending party may, as third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claim against it. But the third-party plaintiff must, by motion, obtain the court's leave if it files the third-party complaint more than 14 days after serving its answer. In her answer to the complaint, TikToker asserted 11 counterclaims against the lawyers. Okay. Argument against procedural deficiency. Oh, wait. Because they are jointly and severally liable for all 11 counterclaims, the attorneys were listed as parties in the caption of the answer and countercomplaint, mentioned specifically in the counterclaims as liable parties and added as third parties to the complaint. Argument against procedural deficiency. Although TikToker referred to attorneys as counter defendants, she followed the correct procedure to add them as third-party defendants. On June 2nd, she mailed separately the request for waiver of service of summons. What that means is she asked the attorneys to say, we're cool, you don't need to be served. Generally, you have to have somebody personally serve a complaint. She was asking them to waive service. It's rare that attorneys agree to waive service. To accompany the mailed documents on June 7th, TikToker emailed the attorneys a second courtesy copy of the waiver request forms, a courtesy electronic copy of the counter complaint, and a request to have the waiver returned by email. They're not going to do that. Speaking on behalf of all 3 attorneys, Olson refused to waive service. I'm shocked. She can't waive service. She's claiming that it's improper. How can... On June 8th, TikToker requested the court to sign a summons for new party counter defendants. The summons were issued the same day on June 9th. They were served at their workplace. The return of the service documents was filed with the court. The plaintiff was electronically served a copy of the counter complainants. Argument against lack of liability. TikToker asserts joint and several liability. Argument against harassment. Third-party complainants are not harassment. Third-party complaints are not harassment. TikToker is an American. Enforcing her federal rights as a United States citizen is not harassment. Attorneys are not above the law. Okay, I agree that attorneys are not above the law. However, the attorneys didn't defame you. They're just doing their job. These things are different. Attorneys are not above the law. Suing an attorney for their fraudulent actions, negligence, and liabilities is not harassment. Argument against need for a motion for joinder. There is a need for a motion for joinder. Ashley Gouillard added the third-party complaint in her responsive pleading answer to complaint. The court's leave was not required pursuant to FRCP Rule 14. Conclusion: for the foregoing reasons, these are proper. I can't wait to see what the court does with this. How is the court going to explain this? Here's the thing. It's like in Clueless, where they're standing up to do the debate of, it was a historical event, but Cher was talking about her father's 50th birthday. And then she's like, Your Honor, I can't do my assignment if she doesn't do hers. Like, how do you, as an attorney, even argue the ridiculousness of all of the things? Because it's like, Your Honor, no. That's not how any of this works. Your Honor, that's not how any of this works. Oh, that's right. Thank you, Cheryl. Haitian refugees. She's talking about some garden party. I don't think the judge laughed. I think the judge facepalmed and went, this is going to go on for a year or two. Oh, she said Haitians. We can totally party with the Haitians. That's what she did. Thank you all. It's his 50th birthday. Thank you all. You have made my day. I left my Cranberry CD in the quad. The attorney, Your Honor, objection, Your Honor, this is not how this works, but they have to deal with it. They have to deal with it because they are in the middle of federal litigation. So let me pull this up. TikToker then filed the email thread. Waiver of service request counter complaint for the case. Ash's God is the email address here to all the attorneys. This is from the TikToker to the attorneys. In the answer and counterclaim for the case, counterclaimant TikToker added attorneys to the counter complaint as new party counter defendants, in addition to counter defendant Professor. On June 2nd, TikToker mailed a copy of the complaint, the waiver form, the notice, whatever, and the waiver by certified mail that should be delivered. To accompany the waiver request and documents sent by mail, this email serves as a second courtesy copy of the waiver. I also added a courtesy electronic copy of the counter complainant. I request the waiver be returned to email address. And then those are attached. And then a second email followed shortly after. from Ash is God. Attached is a signed copy of the waiver request form. Dear TikToker, thank you for your email. As you know, the judge has directed that you follow the rules of civil procedure and of the court. Accordingly, we too are holding you to that standard. Your counterclaims against the attorneys are improper and do not follow the federal rules of civil procedure. Accordingly, we cannot waive service. Best regards, attorney. Then the email response from Ash is God is duty to avoid unnecessary costs of service of summons. Rule 4 of the Federal Rules of Civil Procedure requires certain parties to cooperate in saving unnecessary costs of service of summons and complaint. A defendant who, after being notified of the action and asked to waive service of a summons, fails to do so will be required to bear the cost of such service unless good cause is shown for its failure to sign a return of the waiver. It is not good cause for a failure to waive service that the party believes that the complaint is unfounded or that the action has been brought in an improper place or in a court that lacks jurisdiction over the subject matter of the action and over its person or property. A party who waives service of summons retains all defenses and objections except any relating to the summons or to the service of the summons and may later object to the jurisdiction of the court where the action has been brought. If waiver is not used, the plaintiff must serve process as stated in the rule, but may recover costs from the defendant. She's going to try to recover costs for service. Good evening, Miss Gouliard. None of Professor Schofield's attorneys are parties to the complaint against you. They are her counsel. Thus, a counterclaim against them ordinarily does not comply with the Federal Rules of Civil Procedure, absence a leave of court to add parties. Joinder. In addition, the reasons set forth in the motion to dismiss your counterclaim against her, your asserted counterclaims against counsel are frivolous, lack a basis in fact, and are brought for the purpose of harassment. FRCP 11 provides that by submitting a signed pleading with the court, a person, including a pro se party, TikToker, is certifying that, among other things, the claims, defenses, and other legal contentions are warranted by existing law or by non-frivolous argument for extending, modifying, or reversing existing law or for establishing new law. And the factual contentions have evidentiary support, like a reasonable belief that evidentiary support exists. None of your claims are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law for establishing new law. None of the contentions in your claims include actual facts or have evidentiary support. Violations of Rule 11 may be punished by sanctions from the court. Your counterclaims against the attorney or against the professor are frivolous and in clear violation of Rule 11. Your purported claims against her counsel are even more so. The court eventually will rule on the motion to dismiss and your counterclaims. If you persist in your frivolous claims against counsel, we will seek sanctions against you under Rule 11. It doesn't sign off with govern yourself accordingly, but it's giving govern yourself accordingly vibes. The response on Sunday at 11:13 p.m., because this is a Sunday at 10:10 p.m. response. Attorneys, stop responding to emails on the weekend and at night. Set boundaries. Live your life. Unless you are on strict deadline, let's do this for the profession. No one deserves a response on a Sunday at 10 o'clock at night. It can wait till Monday. Lawyers, let's set boundaries. All of us will do better if we do that. That's just a rant. There are horror stories I have heard of like partners sending their associates emails on the weekend at like 3 a.m. and expecting a prompt reply. The govern yourself accordingly is implied with the time and tone. Yes, it is. Boundaries. Anyway, Sunday, June 11th at 10:11 p.m. Sunday, June 11th at 11:13 p.m. Evening, you continue to be dishonest in your dealings with me in the court. I will continue with all of my actions. Well, it is a clean and concise statement. I will continue with all of my actions. I felt we needed to go through the emails before we got to the motion for sanctions, didn't you? Ash's God then responded at 11:29. Oh, Impact Nightline did a series on this. This episode shows how I've been painted in negative ways by Wendy Olson. I did a Jen Shaw episode of Impact Nightline that I really liked doing. I didn't know they did one on this. I'm going to have to go find it. It's on Hulu. I'm not suing any of you for Rebecca's actions. I'm suing you for your actions and negligent actions. This email is not govern yourself accordingly. This email is, I said what I said. The TikToker has been unwavering and steadfast in their course of action. I think they are able to the lawyers are able to foresee the way this is going to go. I think that that legal clairvoyance perhaps is absolutely right, because this is I am going to proceed. This is a burn the boats email. I will continue with all of my actions. Well, I appreciate the candor. I mean, appreciate the candor. So then, oh, the link actually works. Damn. The link pulled my Hulu up immediately. Hold on. Hold on. Where is this episode? I need to make myself smaller. There we go. If looks could kill, vanished children of the prophet, never made it home. That is a story about the Memphis case. The King Road killings. This is probably where it is. Episode 30. Wait, I forgot they did a Scandival episode. I need to go catch up on Impact. Where's my episode of Impact? Hold on. It's down here. This one. The Housewife Scam. That episode 12 is the episode I'm in of Impact on Hulu. So if you head over to Hulu to check it out, Anatomy of a Scandival, I have not watched yet. And the King Road Killings, I have not watched yet. So anyway, episode 12 is the one I'm in. I didn't realize there would be so much self-promo today. Sorry, y'all. All right. I didn't realize the link would pull up. I'm delighted. So that was June 30th. We then get a reply in support of the motion to quash and a motion for sanctions, both of which we're going to go over now. And then we get a reply in support of the motion to dismiss. But since we're in motion to quash land, let's do the reply. Let's do the reply. Okay. This is the professor's reply in support of the motion to quash the summons against the attorneys. With each filing, TikToker further reveals the outrageousness of her statements against plaintiff Rebecca Schofield and the harassing purpose behind her attempts to bring Professor Schofield's attorney into this litigation. In her opposition to Professor's motion to quash, TikToker doubles down on her prior admission that she has no facts to support her statements about the professor, stating instead that TikToker used her spiritual practice, psychic abilities, metaphysical tools, and investigative skill to uncover the motive and details that led to the murder of the students. To be certain, the attorneys are like, are we still doing this? To be certain, TikToker has failed entirely to ever allege a single fact supporting her false statements. TikToker goes on to use this court as a platform to further harass and defame the professor. Right that Gouliard's TikToker's spiritual investigation revealed that the professor planned, initiated, ordered, and executed the murder. With her false and increasingly distasteful statements, remember, unfortunate and distasteful are the words the court previously used in a footnote about the statements. With her false and increasingly distasteful statements, TikToker also admits why the summonses directed to the attorneys should be quashed. She now says that she mistakenly referred to the attorneys as counter defendants. She meant to add them as third-party defendants. that shift makes sense because the attorneys are not parties subject to counterclaims under Federal Rule of Civil Procedure 13A or B. And TikToker failed to seek leave to add non-parties under Rule 13H. Right. She didn't seek a joinder motion to add third parties. She tried to add counterclaimants. They're not counterclaimants. They're not claiming against her. They're the lawyers. They're not parties. Yes, yes, yes. It has gotten suspiciously dark again today. Our weather continues to be adventurous. But through that shift, TikToker also has not properly brought third-party claims against the attorneys. Right. Because you have to have leave to join them. The amount we've ended up talking about joinder on this channel, something that when I left law school, I was like, we're not going to have to, like, this is not something I'm going to have to deal with in criminal practice. And then I ended up doing this and I'm like, damn it, now there's joinder all over the place. Joinder here and joinder there. We got to joint tortfeasors on Tuesday. It's fascinating. As TikToker acknowledges, Rule 14A1 states that a defending party may, as third-party plaintiff, serve a summons and complaint on a non-party, oh, there's the rain, who may be liable for all or for part. The third-party claim must direct liability asserted, et cetera, et cetera. TikToker attempts to assert liability against the lawyers based solely on her purported counterclaims filed with her answer. Nowhere in those counterclaims and nowhere in the record does TikToker claim that attorneys are liable for defamation against the professor, because they're her attorneys. Nor did she seek the court's leave to file the claims. Indeed, this is going to get heated. Indeed, even if such an allegation were made, it would be absurd to accept that the attorneys of the professor hired to pursue her defamation claim are the very parties responsible for defaming her. Where else did we see this argued? We saw throwaway arguments in a motion to dismiss against the Toddy Westbrook case when it was, if you are suing defendant for defaming Toddy Westbrook, then you also must sue like a whole bunch of other YouTubers, like James Charles and Jeffree Star and Shane Dawson and a bunch of other people were named in that. And it was like, if you're going to sue this, you need to sue all of that. So, and that what motion was not made, but it was argued kind of like there's all these other people that would also be responsible. Here, the purpose of bringing in the third parties is more akin to the argument that Murdaugh just made. Murdaugh just argued in the Satterfield part of the case that if you are going to go forward against Murdaugh in the insurance case, that you can't really do it without bringing in the Satterfields. It's in the insurance case, sorry. In the Murdaugh insurance case, he said the insurance company can't go forward against him without bringing in the Satterfields, who got paid by the insurance company and their lawyers. So he was saying, look, you can't just go after me. You have to bring in these other people to go after. We are all responsible. I disagree with that assertion, especially when it comes to Murdaugh. But you can't argue here that the lawyers defamed their client. It's not the same as Murdaugh saying, if you're going after me for the insurance money, you have to go after all these other people for the insurance money too. They're different. Does that make sense? Hopefully that analysis made sense. Or the this and that made sense. Let's see if I got very purple all of a sudden because the light outside changed. So hopefully that made sense. Indeed, even if such allegation were made that somehow these parties were responsible for the defamation, it would be absurd to accept that the attorneys Professor Schofield hired to pursue a defamation claim were the parties responsible for defaming her. Therefore, Gouliard cannot join them as third-party defendants. Which is interesting because I think what the TikToker is trying to argue is that the attorneys defamed her, right? The attorneys are responsible for defaming TikToker. And the attorneys are like, we can't be responsible for defaming you through our filing. Gouliard's repeated disregard for the rules permeates each of her pleadings. Sorry, the rain is being sketchy. Permeates each of her pleadings and indicates an intent to harass the professor, delay the proceedings in this case, and increase litigation costs. There is no exception. Professor is not claiming that all third-party complaints are harassment. Rather, Professor asserts that these particular attempt to bring in the attorneys under a deficient third-party complaint shows a blatant disregard for the rules and therefore constitutes harassment. Not only is the claim that the attorneys mocked, denounced, and discriminated against TikToker in furtherance of a conspiracy to deprive her of her rights of property unsupported by facts, but the procedures TikToker employed to rope the attorneys in exemplify unprofessional and frivolous conduct. Well, we do know she is a pro se attorney, and the court will grant her a bit of leeway in that. They're not supposed to, but in practicality, they do. The professor agrees and further provides that TikToker is not above the law either. The law does not support TikToker's attempt at joining these non-parties in the action. Therefore, the summonses issued against the non-parties should be quashed. And the purported claims should be dismissed. For the foregoing reasons, the professor requests that the court dismiss the counterclaims against the attorneys and quash the summons. All right. Let's get on to the motion for sanctions, shall we? Because that's what's next. All right. Motion for sanctions. I should swoop. I'm so distracted by the rain. I don't know if you guys can hear it. The mic's probably not picking it up. No, but it is loud. All right, motions for sanctions. Plaintiff, through her counsel, has legitimately sued defendant for defamation. In response, TikToker has tried to file factually and legally frivolous counterclaims against non-parties attorneys, alleging that as the professor's attorneys, they have violated federal civil rights statutes and committed other torts by doing their job. Filing a legitimate lawsuit and responding to press inquiries about the lawsuit. Under FRCP 11, the court should sanction the attorney, or the attorney should sanction the TikToker, acting as her own attorney, by dismissing the purported claims against the attorneys and awarding plaintiff the costs and fees incurred to bring this motion. In accordance with Rule 11 Safe Harbor provision, the instant motion and associated memorandum were sent to Gouliard on June 21st, 2023. They gave her notice to allow her to rectify her actions, saying, hey, reverse course, or we will file a motion for sanctions. So you give someone the opportunity to withdraw the pleading or whatever it is. That was not withdrawn. The email was very clear. I'm going to continue doing all the shit I'm doing. And so here's the memorandum in support of the motion for sanctions. Defendant TikToker has received a second chance to participate in this litigation after defaulting, and she has abused that opportunity by attempting to file 11 frivolous quote-unquote counterclaims against the professor's attorneys. TikToker's claims are frivolous because FRCP 13 permits counterclaims against an opposing party not counseled to a lawsuit. To sue non-parties like attorneys, TikToker needed to follow the procedures to file third-party claims under FRCP 14. Even if Gouliard could collect these procedural infirmities, her claims are factually and legally frivolous for the reasons provided in the motion to dismiss. Even if she went forward on a motion for joinder, the motion for joinder would be denied. So if TikToker brought a motion for joinder to the court, that would look like TikToker going to the court, hey, these people aren't parties, and I want to make them parties. And I need you, court, to grant me leave, approve, and allow me to bring these other parties into the lawsuit. And the court would take a look at it and go, no, you can't add the lawyers to the lawsuit. And then it would be done. You can't just try to shoehorn it into a counterclaim because it's not a counterclaim because they're not parties. So, Professor, through counsel, filed a defamation action after TikToker admitted posted hundreds of videos online stating that the professor had an inappropriate affair and ordered the murder of 4 students based only on TikToker's spiritual research, intuition, and insights. TikToker has responded to counsel's legitimate legal work by alleging that counsel conspired to deprive TikToker of her rights in violation of a host of federal civil rights statutes designed to prevent obstruction of justice and witness tampering. Even as a pro se litigant, this behavior cannot be tolerated. Counsel for attorneys have made numerous attempts to resolve this issue with TikToker, short of seeking sanctions. She has refused every time. Yes, her response has been, I said what I said, and I will continue doing what I am doing. Thus, under Rule 11, the court should sanction TikToker for her attempted counterclaims against the attorneys. Now, the sanction they are asking for is dismissing the claims and awarding fees and costs incurred with the motion. The court could choose to dismiss the claims and not award fees and costs. We will see. The background, we know the background. We've gone through it. They say that TikToker devised a scheme to leverage the tragedy in Moscow for her own personal gain, using her quote-unquote spiritual acuity to post sensationalist content online to attract clicks and make money. The false story that she posted repeatedly is that plaintiff professor at the University of Idaho had a same-sex affair with one of the victims and then ordered the murders to cover up the affair. TikToker herself admits to posting over 100 TikTok videos related to her findings about the professor. The professor tried to resolve this matter without litigation to avoid drawing further attention to the specious statements. Yes, she wanted to avoid the Streisand effect of filing this lawsuit and having it be covered more. To draw attention to the specious statements at the expense of the victims' memories and their family's trauma and the professor's reputation and family safety. She sent cease and desist letters in November and December. TikToker acknowledged receiving those letters, even making disparaging TikToks about them. When Gouliard responded by making more false statements, the professor sued. Because what do you do? What else do you do as the professor? We're going to talk about this a little bit at the end because I have thoughts about this. I have a lot of thoughts. I have thoughts. Instead of timely responding to professor's claims, TikToker prolifically posted new videos and blogs defaming professor, accusing law enforcement of corruption for arresting and prosecuting Brian Kohberger for the crimes. To end the spectacle and to hold TikToker accountable for disregarding the court's deadlines, the professor requested a default judgment. The court exercised its discretion to give Gouliard, a pro se litigant, who promised this court she would be timely and responsive, a second chance. TikToker has used her second chance to file frivolous counterclaims that serve only to delay adjudication of the claims, further harm the reputation of the professor, drive up her litigation costs. She also used her second chance to attempt to drag the attorneys in as parties, which they are not. In her claims, TikToker offers not even allegations of real evidence that professor knew any of the victims, had an inappropriate affair, or ordered the murders. TikToker instead admits that she has used her spiritual acuity and investigative skills to get insight into the murders. In other words, she made it up. Gouliard says her quote-unquote spiritual research intuitively led to the University of Idaho History Department. She then spiritually inquired into each person listed on the History Department's webpage. Her insight for the professor revealed that she was in a relationship with Carlee Gonsalves that broke up and that she initiated the murders, planned the murders, and hired help to carry them out. Legal standard Rule 11 makes every signature on a pleading, motion, or paper a certification of the merits of documents signed and authorizes sanctions for a violation of certification. Specifically, Rule 11 requires an attorney or unrepresented party to certify any pleading, written motion, or paper presented to the court that 1, it is not being presented for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law or establishing new law. The factual contentions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after opportunity to fully investigate, further investigation or discovery. The denials of factual contentions are warranted on the evidence of, or specifically so identified, are reasonably based on belief or lack of information. And that's where you said, where you see, you see it in pleadings, reason to believe, or based on this or that. You see it you know, you see it pled out when it's like, we have reason to believe that this is the case. The sanctions available for violation of these standards include non-monetary devices. My brain has just stopped. Non-monetary directives in order to pay a penalty into the court, or if imposed on motion and warranted as an effective deterrent, an order and directing payment to the movement of part or all of the reasonable attorney's fees and other expenses directing from the violation. And you see attorneys ask for this all the time. Thank you, Ashley. On information and belief, my brain has literally stopped at the end. This is why I try to stream for less time. My brain was blah, blah, blah. Ashley Galliant pulled up the language that was escaping my brain. Thank you, chat. The chat is the best. Rule 11 places an affirmative duty on litigants to make reasonable investigations of the facts in law before signing and submitting the paper. A reasonable investigation requires litigants to seek credible information rather than proceed on mere suspicions or supposition. Credible information may consist of either direct evidence or reasonable inferences from other evidence. I imagine that TikToker is going to say, I have direct evidence. I think that this is true. But that is not going to be founded on other evidence. There would need to be other evidence. Chat EDB is the best. Rule 11. Under Rule 11, a court may impose sanctions upon unrepresented parties for submitting papers to the court that are frivolous, legally unreasonable, baseless, or filed for an improper purpose, such as harassment. And I think the court is probably going to grant the motion to dismiss and the motion to quash. I don't know if the court will grant attorney's fees. I imagine that when they have a hearing on this, the court will verbally, strongly admonish the TikToker and not grant the attorney's fees. But the court could. But this court has given a little, we've seen this court give a little bit of explanation and saying, but we also saw the court say, I'm going to hold you to the standards of a lawyer, which is what they're supposed to do. When you represent yourself pro se, you are acting as a lawyer, and the court is required to treat you the same as a lawyer. Now, in practice, sky color is a little sketchy for me. In practice, we have seen the court give a little bit more grace, right? Like in the Brooks case, this happens particularly in criminal cases. But in the Brooks case, we absolutely saw the court giving Darrell Brooks more leeway than any attorney would ever be given. But Darrell Brooks was also facing multiple life sentences, and the court was like, we just have to get through this. It's a little bit different if the pro per was a plaintiff, but it's a lot different when the pro per is a defendant. But this is a civil case, and you're not worried about an issue of liberty here, and the court can be a little bit more heavy-handed. Let's see. Sorry, I had to go check the weather. It looks like severe thunderstorms, but not spinny wind. Okay, good. All right, we're good. I needed to check. My brain needed to tick that off the list. Kepi, I agree she should have to pay her lawyer's fees. I just don't know if the court will do that. M. Spruce, the chat's been weird all day. It's not on slow mode that way. The chat has been off and on. So I am checking the weather. It looks like a severe thunderstorm, but not spinny wind. So straight line winds, but not spinny winds. So we're not green. We're not green yet. That's why I was looking a little bit more. I was like, which way is that sky going? It looks a lot better now. So we're not worried about the swirly winds. So, yep. No spinny wind. I'd ever pay the lawyer's fees. The filing fees. We'll see what happens. But yes, because at the end of the day, the professor has to litigate this stuff. All right. Let's continue on. I feel better about the weather. We've only had to cut the stream for weather once. So we're on a good track record. A party's pro se status does not shield them from Rule 11 sanctions for pursuing claims that are neither warranted by existing law nor based upon a good faith argument for modification. There's a part of me that's like, the TikToker is going to argue to the court. I believe, like, I have a good faith belief in this. I have a good faith belief. They are going to argue that they believe this wholeheartedly, and that's where the court is going to have to start making some judgments, right? And we do see the courts give people chances. They don't just drop the hammer. And again, I think when we see a ruling on this, it'll probably be the dismissals and the quash and a stern admonishment and not monetary sanctions. Could be wrong. A pleading is frivolous if it's both baseless and made without a reasonable and competent inquiry under the circumstances. Subjective bad faith is not necessary to impose sanctions. When determining whether a complaint is frivolous, the court need not accept allegations as true, but must pierce the veil of the complaint's factual allegations to determine whether they are fanciful, fantastic, or delusional. And so what the attorneys are arguing is the difference between a motion to dismiss where the standard is you believe the allegations as true versus the motion for sanctions where the court can look beyond that and say, is there actually any evidentiary support behind this? Argument. Gouliard alleges that by filing a defamation action on behalf of the professor, the attorneys are personally liable to TikToker for defamation, obstruction under federal civil rights statutes, malicious prosecution, and intentional infliction of emotional distress. No. Rule 11 allows sanctions if a filing is legally frivolous or factually misleading. The pleadings suffer from both defects, as explained in detail in the motion to dismiss and summarized again here. And we've seen this in the motion to dismiss. Excuse me, since we are over 2 hours in, I'm not going to read every single bit of this, but we've gone over it and over it and over it. The attorneys are not conspiring to deprive Gouliard of her rights as an American citizen to free speech. By the way, your right to free speech is not a right to defame. Gouliard's, quote, factual allegations are fanciful, fantastic, delusional, and patently lacking in merit. Gouliard does not allege a single shred of direct or circumstantial evidence or an actual fact suggesting that the professor had an affair with a student or ordered the murders. TikToker merely says her spiritual research intuitively led her to the history department, and then she inquired. TikToker does not allege anything sufficient to allege a conspiracy to violate federal civil rights statutes. The only basis for the claims against the attorneys is that they did their jobs, file a legitimate defamation lawsuit, and respond to press inquiries. Gouliard's claims are not supported by law, and we've seen all of that in the motion to dismiss. Conclusion, no reasonable party, pro se or otherwise, could make the certifications required by Rule 11 with respect to the putative claims against the lawyers who did nothing more than advise and represent their client regarding the proper response to the malicious and unfounded attacks on the professor. The court should sanction TikToker by dismissing her claims, awarding costs and fees. And that is the motion for sanctions. I think that the court will grant the motion to dismiss and the motion to quash. I can't imagine, particularly with the motion to quash, I can't imagine the court not granting it. I will be very surprised if the court doesn't. We will see what happens with the motion for sanctions. It's not been, the motion for sanctions has not been, none of these motions have been heard yet. When they are heard, I plan on attending those hearings via call-in or Zoom. I'm very curious to hear what the court says, and I will report back to all of y'all. There is one more motion. It is very short, and we are just going to do it now. And then we are all caught up on all of the litigation in this case. Y'all, can you hang with me for one more? Can we do it? Can we do it for one more? The amount of litigation in the early stages of this case is, let's see. You guys are doing great on Stormwatch. Chat, thank you. I don't know if Nashville Severe Weather is live on YouTube, but thank you so much. I appreciate you. I appreciate you're like, let's do it. Let's do it. Let's do it. Let's do it. Perfect. Let's do it. One more. Let's do it. This is the reply and support. It's a pretty short one. Hold on. Let's get this to the right size. All right. Reply in support of plaintiff's motion to dismiss defendant's counterclaims. Defendant Ashley Gouliard's opposition brief further shows the legal and factual frivolousness of her claims. TikToker continues to defame professor by saying that she planned, initiated, ordered, and executed the murder of 4 students. And in the stricken brief, she goes even further to say that the professor is a serial killer. She did say that, but the brief has now been stricken. But she did call the professor a serial killer. She did do that. TikToker also reaffirms that she has no basis for her increasingly inflammatory statements, relying only on psychic abilities, spiritual acuity, and investigative skills. Gouliard is free to practice any spirituality that she likes, but that spirituality does not excuse attacking another person's reputation or warrant using this court as a platform to harass the professor, drive up litigation expenses, and further the scheme to make millions of dollars. Id at 3. Through Rule 8 and its inherent power, the court can and should police such abuse. That is, the court can draw on its judicial experience and common sense to dismiss the counterclaims because they are fanciful, fantastic, delusional, and patently lacking in merit. Although that finding alone is enough to resolve all of the counterclaims, TikToker has further proven why her claims fail legally, even if the court were willing to look past the frivolity of her factual allegations. To start, TikToker makes even clearer in her opposition brief that the basis for most, if not all, of her counterclaims is not something that the professor alone has allegedly done, but rather an alleged conspiracy between the professor and her attorneys to file a defamation suit. Quote, "It is axiomatic that an agent acting within the scope of her representation cannot conspire with its principal, and the relationship between an attorney and client is one of agency in which the client is the principal and the attorney is the agent." Yeah. CEG, all of our conversation during Deppy heard about attorneys and agency and who's responsible for statements. There is nothing more clearly within the scope of an attorney's representation than drafting and filing of a pleading. It is literally what they do. Looking to TikToker's individual claims, the professor's opening briefing explains the many legal flaws in the claims. In this reply, she will touch briefly on the major flaws that are further exposed by the opposition brief. For the defamation counterclaims, TikToker offers no explanation of why 28 U.S.C. 4101 applies here. Even if she is allowed to pivot to a state law defamation claim, her argument that the privilege against defamation for statements made during a judicial proceeding applies only in criminal cases is incorrect. Accurate. Accurate. That litigation privilege covers, and that's accurate. For the 42 U.S.C. 1985 claims, TikToker acknowledges that she has not claimed to be a party to the Kohberger case. That fact does not make the argument moot. It makes her argument right. All of you in the chat that are screaming pivot, yes. Pivot! Since TikToker plays no role in any court proceedings related to the murders at the University of Idaho, there cannot be any obstruction or witness intimidation. And without a 1985 claim, TikToker does not have a 1986 claim because they go together. Yes, it is a moot point. They've argued all the things. They've argued pivoting, and it's a moot point. For the 1983 claim, TikToker says she has alleged a state action because defamation cases are decided under state law. TikToker misunderstands the meaning of under the color of state law in the 1983 actions. They said that kindly. Quote, "An individual acts under the color of state law when he or she exercises power possessed by virtue of state law and made possible only because the wrongdoer is clothed with the authority of state law. This test is generally satisfied when a state employee, like a deputy district attorney, wrongs someone while acting in his official capacity or while exercising his responsibility pursuant to state law. Virtually every legal action is authorized under either federal or state law. If filing a cause of action authorized under law were enough to create a liability under 1983, then every litigant would fall under 1983's purview. That, of course, is not the case. For the malicious prosecution claims, TikToker says professor's defamation claims, quote, are likely to fail. Professor disagrees, but more importantly, Idaho law requires more, that an action be terminated in favor of plaintiff. Professor's claims against TikToker have not been terminated. Like, these claims are premature. TikToker thus cannot bring a malicious prosecution claim. The IIED claims, TikToker still does not allege anything outrageous. Outrageous. Professor filed a lawsuit to remedy damages to her reputation. That action is not unusual, let alone outrageous. Whose behavior in this is outrageous? Anyone? Anyone? Bueller, at bottom, more than a year after starting her relentless attacks on the professor on the internet, TikToker is getting closer to facing the consequences in real life. She has responded by yelling louder and grasping at increasingly thinner air. TikToker's latest antics, filing claims that are factually and legally frivolous as a vehicle to keep attacking the professor, do not warrant any further expense or delay in this litigation. For those reasons, and the reasons provided in the opening brief, the court should dismiss the counterclaims and award Professor her attorney fees. All right. I understand why the attorneys are like, we didn't want to amplify this. They didn't want to Streisand effects the claims against the professor because the claims have gotten louder and louder and louder, right? If you guys follow Peter Mon, if you follow what's going on with Colleen Ballinger, if you follow Mandy Matney and others who have recently been speaking out against things like internet harassment, this comes up there too, right? You see people struggling with, do I talk about this and potentially draw more attention to it? Or do I not talk about it? Do I defend myself? Do I not defend myself? And you saw in Mandy Matney's case, choosing to wait until those that were harassing her and her company and others in her company until the Reddit that was doing that was taken down and choosing to talk about it later. With Peter Mon, you saw him taking action behind the scenes and then speaking about the action that he was taking in YouTube videos. But when people are dealing with internet harassment, and that's what this professor is suing over, is internet harassment. When you see people dealing with internet harassment, there is this really difficult balancing act of, when do you speak up about it? When do you talk about it? When do you bring those things to light? And will bringing it to light make it worse? Will it subject you to more harassment? In this case, we've seen both the TikTok creator and the professor talk about substantial harassment that they've received. And whatever you think of the TikToker's claims, I'm sure a lot of us think the same way. We're just like, good Lord, what is happening here? It still doesn't justify doxing people and making death threats against them. It doesn't just, like, harassment doesn't justify further harassment, right? And it gets so hard because it seems that very often the response when people speak out about things is harassment. We've even heard Adam McIntyre talk about this when everything came up this year about Colleen Ballinger, when people exposed text threads and DMs and the rest of it, he was receiving death threats and harassment for something he didn't start talking about, for messages he didn't share, but that he was a part of. He was included in that conversation. And because of being included in that conversation by someone else, he and his family were subject to death threats and people following him and stalking. It's fucking wild. And so I'm not surprised that people don't know how to navigate this. I'm not surprised that the professor and the attorneys are like, we tried to shut it down and we couldn't. And now we've had to make it bigger. Now these allegations are connected to this professor's name forever, no matter what happens in court. And the thing, I didn't realize I was going to soapbox. And the thing that I'm so frustrated in seeing with, like, the Erika Girardi stuff with the earrings is that everyone covered, myself included, everyone covered the turnover motion. And we're like, the court's making her turn over these earrings. But there's been no coverage on the appellate court saying, actually, it hasn't been proven that she needed to turn over these earrings. It hasn't been proven that these are ours. Silence. So again, it's fine to criticize Erika Girardi's behavior in light of these things coming to light, in light of learning these things. it's fine to talk about the legal filings, but where is the rest of the coverage? It all just kind of stopped. And I had no idea that ruling had come down until I started looking at the Girardi competency stuff to update it in the podcast. And then I was like, well, if I'm updating the competency stuff, what other open loops are there? And then swung back to all the open loops and went, oh, there's a appellate court ruling. There's actions to disbar these other attorneys, which I hadn't seen either. There's all this other stuff. And so I was like, well, there's all this other stuff. Why isn't anybody talking about it? Like, if we're going to follow through with court in a way that is, for me, in a way that feels responsible, then we should cover, I feel, all the documents, which is why we end up talking about the same 10 cases over and over and over again, because I want to follow through on the thread, not just the, Erika loses in court. Okay, well then when Erika wins on appeal, shouldn't that be covered too? I think that's only fair. And then when it gets remanded, we cover that too. Because we need to tell the whole story. And in litigation, the whole story comes out in bits and pieces. It's like the Toddy Westbrook case. Tons of coverage on the initial lawsuit filed by the business partner. And then it decreased. And then Me Too decreased. And you guys are like, what has happened? I'm like, we're getting back to it, I promise. But then the coverage decreases as other cases pop up. And I understand why. But again, if there is a huge ruling that's covered everywhere, if it's turned over on appeal, maybe have a conversation about that too. And it's the same with this stuff. I mean, when I'm looking at a defamation case over internet harassment, this case makes me sad for the professor. The harassment is not okay of the TikToker, because this can be litigated in court, but it getting louder is why so many don't talk about this kind of harassment and tend to try to let the air go out of it and walk away. And though when Peter Mon has been talking about the kind of stalking and harassment he's been dealing with, it's like on a whole nother level, but content creators deal with it quite often. And it's come up in conversation a lot lately. Being Mandy Matney's talked about it in multiple podcast episodes. She had victims' families on to talk about the type of harassment that they get when they come forward. We've seen Adam McIntyre talking about the harassment he gets. It makes it hard to cover stories when it seems like the response to that is to harass people. I don't understand it. I don't understand why we can't have a conversation without it going to like death threats against people who are talking about things. It's as if there are those on the internet that would like everyone to shut up, and that's not going to happen. So for all of the creators, for all of those that are like, hey, I'm not going to shut up, I appreciate that. I appreciate the bravery it takes to start to unmask those that are doing it, because the fear is it will get worse. And the fear is that it will get worse. And I can see, you see it in the professor's filing in this case, which made me think of all the other conversations around this that have been happening in the last few weeks, because you think it will get worse. Laura M said in the chat that Peter Mon said he was here for his defending himself era. Exactly. And it's hard when it's the internet, because it's hard to unmask anonymous accounts. It's not easy, but I'm watching other creators do it and do it bravely. And I'm inspired by that, because people aren't going to let their voices be silenced when they're talking, particularly when you're talking about either your personal experiences like Adam McIntyre and Peter Mon, or talking about stories that you're covering. Mandy Matney's like, I'm covering the Murdaugh story. You don't agree with my take? Fine, don't listen to my coverage. But you don't need to, stalk, threaten, dox, harass, follow. That's way too far. And I think we're going to see the courts become more sensitive to this. I think we are going to see more people going after anonymous accounts, because nothing is truly anonymous on the internet. And I think we're going to see more people going after anonymous accounts the way that Mandy Matney and others have behind the scenes. A lot of people take that action behind the scenes first. And even with this case, we saw the professor trying to deal with this behind the scenes first. But I think we're going to see the complete anonymity being stripped away. And I've seen numerous creators go after subreddits. They can find people posting anonymously and do. They can find Twitter posters posting anonymously and do. So I think we are seeing a shift in the courts. I think we are going to continue to see a shift in the courts with this. And I hope that we will see a commensurate shift in the laws, because cyber harassment is an issue. And I think we'll start seeing some of those like harassing phone calls laws expanded to cyber harassment. I absolutely think we will. So with all of that, my thoughts are, Law Nerds, I appreciate you, because while there are pockets of the internet that act a complete mess, those are pockets. We have shown that we can have tens of thousands and sometimes hundreds of thousands of people having conversations about things that are sensitive, that are difficult. And we can have conversations about the things without attacking the people. And I appreciate you. I appreciate you for that, because there's a way to have a conversation. We're supposed to have a conversation. Jurors have conversations about these things. We're just having conversations about the law. And we're going to keep having those conversations. So let's get to questions, right? The sky has all of the opinions today. The way that the air is growling outside of my house right now is something out of a Garth Brooks song. I'm not mad about it. I don't mind. I love a growly sky. It's gotten all emo and dark. What is your weather today? Emo. Is that a fair description? Is that a fair description? Do you understand? You all are like, yes, I get it. All right, let's get to questions, shall we? It's time to fact around, and then I have a phone call that I need to make. All right, let's go. We are going to go somewhat quickly through Q&A because I talked too much. I do that sometimes. All right. I'm sorry if Thunder Rolls is now stuck in your head. As long as it's got the extra verse. Amanda said, Emily, I just got into law school with a full tuition scholarship. I wanted to send this super chat for months. Today is the day. Amanda! Congratulations. And also, I'm excited for you. You are going to embark on quite an adventure. And your 1L year, your brain is going to do this to you. And please keep us in the loop. You are going to be like, oh, that's like this case. Oh, joinder. They tried to do that in H3H3. They tried to do that in this case. The 1L learning is going to tie into so many of the cases we've covered. I very much hope you have friends that you find that also love the pop culture world, so you can be like, oh my God, this is kind of like that one motion in the Jen Shaw case or what have you. I think it's going to be very interesting. So let's continue on. Can a litigant actually use because I felt it as an argument, use the force? Can she say ineffective counsel? She can't say ineffective counsel. There has to be evidence. There has to be some supportive evidence. And independent testimony can be evidence, but you have to be a percipient witness. Like, if you see a car accident, this has happened to me because I've given statements after I've witnessed car accidents, and you say, I saw this car do this and that car do this and then this. And then there's also the additional evidence of the cars where they are. There's evidence that that thing happened, right? There's both my percipient witness testimony where I saw it happen, and then there's also the physical evidence of the vehicles. You can have testimony where somebody just testifies to what happened to them. this thing happened. And I saw this and this and this, and I heard this and this and this. But if you have not seen it or heard it or done it yourself, it is not going to be admissible testimony, which gets to, if psychic-derived evidence is inadmissible, why isn't this tossed already? Well, it's on the motion to dismiss the counterclaims, and that's coming up for hearing. So you've still got to go for procedure. The court can't just read it and yeet on their own. You still have to follow procedure. Follow the rules. Could the judge close the case as it has no prospect of succeeding, or is that only in criminal cases? So the attorney case is different because that was after the first part of a trial. And that was after evidence. That happens in civil cases on summary judgment motions. The summary judgment motion standard is different than a motion to dismiss. Can that happen on a motion to dismiss? Yes, it can happen on a motion to dismiss. And a motion to dismiss, though, has a different standard and a lower standard than like a summary judgment motion. A summary judgment motion is like, I've seen the evidence, and on all of this evidence, if this is all that exists, this case cannot go forward. A motion to dismiss is, well, if these things are true, then the case go forward. It assumes the truth of what is said. So on the motion to dismiss, the court has to assume everything the TikToker says is true and then still find that the case can't move forward. So it's a little bit of a different standard. Sassy J in the UK said, sadly, I feel TikToked off. My aura wants to sue me. I'm sorry that your aura is mad at you. Is amber the color of your energy today? Oh. Mm-hmm. My aura ring wants to sue me because I haven't been getting enough sleep lately. Question. Is a stay different than a continuance on paper? Yes, Nikki, absolutely different, particularly in this circumstance in Idaho with a criminal case. A stay freezes the case. Like a bankruptcy stay stops the case from going forward at all. A continuance just trails it out down the road. Yes, good question, very different. Whatever happened to predictability? Sorry, I'll show myself out now. Whatever happened? Thank you, music to my soul. Matt Bond, good to see you. Hi, my spiffy legal mumbo jumbo talkie friend, listening to Brittany and Will I Am while watching. Is it? Oh, you live in the future. That's right. Tomorrow. There's so much happening tomorrow. BravoCon tickets go on sale tomorrow. The only thing guaranteed, IRS and death. Yes. That applies to several things we've talked about today, doesn't it? Esme said, thank you for not jumping on the shame bandwagon. Even if this wasn't real, there are so many women going missing that it hurts to see people using this as a reason to not believe the next woman. Esme, you are welcome. I don't believe shaming people is going to be helpful. I believe asking questions. That was... Have your moment. I believe, look, people don't just if it is untrue, and it looks like it is probably untrue, but if it is untrue, there are deeper things beyond why people do that or put their family through that. And there's questions to be had there, and the family is going to have to deal with this. But no, I'm not jumping on the shame bandwagon. It is the question of how many resources were spent is a separate question, and they'll deal with it. But I think saying, hey, we need to ask questions, but hey, there are so many people missing, legitimately missing, that we need to keep an eye on that. And if the internet can help, if one person has a dash cam video that could help, we need to still ask for that. We need to still go through that. And we don't need to lose our compassion just because sometimes we're wrong. Like I've had compassion for situations where I'm like, oh, I misread that situation entirely. It doesn't change having compassion for the next situation. We just ask more questions. Tina K.S.Nerd, thank you, EDB, and your staff for working so hard to fix my account. I appreciate everybody's help. The Team Baker is fantastic. The response time was incredible. Love all that you did. You're welcome. Team Baker is great, and I appreciate them. They are fantastic humans. So excited to have caught alive. Yay, typically part of the replay crew. Love you. Thank you for everything. You inspire me. Well, thank you very much. The Law Nerds inspire me. Y'all are what keep me going, too. You know, if it weren't for the Law Nerds, I might just become an NPC TikToker. I'm teasing, but I can't escape it. But I'm part teasing. Mia said, can the police force her to talk? No. What happens if she just doesn't talk at all? If she just doesn't talk at all, there's probably nothing more that can happen. But no, she has a Fifth Amendment right. It is clear that there might be something that could be a crime. So no, they cannot force her to talk, and any lawyer would tell her not to. Thank you so much, Gringa Latina. I have no idea what part of the rant I was in then, but yes. The chat going, oh my God, that's all of my For You page. All. I've stopped going on TikTok For You. I've started looking at people reposting TikToks in their Instagram stories to find the ones that are funny. Did you guys see the one? The one with the woman who wanted Wingstop after a 10-hour work shift and it got put to heavy metal. I will have to find it again and show it to you. It reminded me of the days of like auto-tune the news. And I was just like right back to hide your kids, hide your wife. It was just like, I worked 10 hours. I just want Wingstop. And I'm like, oh girl, I've been there. Not necessarily with Wingstop, but I've been there. It made me miss auto-tune the news, but it was like heavy metal, this woman losing her shit on her friends. Like, I have worked, I have not eaten, just fucking drive. And then when she turns around and calls her friend a squid, like the hanger has like taken over this woman's entire soul, and it's just I can't stop watching it. I need to go. If any of you are on Instagram and have and know where it is, because I forgot to save it, will you please DM it to me, either on Twitter or Instagram or email or whatever, because I very much will need to play it for you guys next week. Because if you and I'll put it in my I'll put it in my stories, because if you haven't seen it, it's so funny. But she's like, I worked 10 hours. All I want is Wingstop. I forgot to like it because I was going to try to send it to, that's a whole long story. I interneted badly, but it made me miss the auto-tune the news days. So that, stoked I caught alive. It's my birthday. AC, happy birthday. Lindy. Hey all, I survived a heart attack to make this live. Good for you. Now I've got to survive a tooth extraction. That will be better. But I'm glad you survived a heart attack. Take care of yourself. And we're glad you're here, Lindy Wilson. I'm sorry that happened. That's a lot. That's a lot. That's a lot. I see the chat. The chat's trying to make me sing. Give me one margarita. God, I love that song. I love that song. It's so good. The music video just came out. It's so good. Thomas, hello. Hey, DB, watching while prepping for the bar, taking the exam next week. Any words of encouragement? Look, the scenarios that we cover on this channel are crazier than any shit that the bar examiners are ever going to throw at you. You need to sleep. You need to hydrate. You need to eat. You need to move. You've already got this. You need to sleep, hydrate, and eat. Your brain does not need you to try to cram any more information into it. You are now in the taper zone, right? You do all the heavy studying, like you do all of the heavy workouts, and then before the finals, you start to taper. Do they call it that in other sports or just swimming? I don't know. Start to taper. More rest, more hydration, brain fuel. Do not let other fuckers get into your head. You can do this. Do not let their self-doubt come into you. Just find the ultimate playlist and tune out the rest of the world until after the bar exam. Just tune everything else out. If meal delivery is what you need, do it. If a massage is what you need, do it. Now is the time to take care of yourself so your brain can process this exam. It is a fucking marathon. Look, if I can pass the bar exam, you can pass the bar exam. I am not a great test taker. I am not the smartest person in the world. You see my memory. I am not one of the attorneys that can be like, oh yeah, it's an international shoe. Bleh. It doesn't all stick in my brain. It's about thinking, you can do this. You've got it. Those are my advice. When I was studying for the bar exam, one of the attorneys that I had law clerked for and then ended up working for gave me basically the same advice. You need to sleep. You need to hydrate. You need to eat. You need to move. So it is time to stop cramming information into your brain. It is time to taper. What are your thoughts on the Chicago student professor situation? I have no idea what that situation is. Wasn't there something about earrings being stolen? With Erika Girardi, this was apparently a replacement pair of earrings. Stina G said toddler kids are well-known tactic to pick up women for trafficking. It happens every day, everywhere. I can't verify it happens every day, everywhere, Stina, but it's scary because it's relatable. Yes. And that's part of why there was so much. My moderators have worked at the fucking swiftness of light. Miguelina, you are a queen. Thank you. You have made my day. We're going to go out with a TikTok. For all of you that haven't seen the Wingstop one, the one about the Wingstop is absolutely... The swiftness with which this happened has made my fucking day. Hold on. We're going to do this. I am so happy that we're doing this. Miguelina, thank you. All right, I'm turning the volume all the way up. Hopefully it's not too loud. It starts with the text, "We just picked her up." All right. This is like where Danger Floof came from. So thank you. This is what we're going out with. It might become my theme song. Because I feel her pain in my soul. I do.
I worked 10 hours! All I want is Wingstop! That's a little excessive. That's a little excessive. CEO is angry. I'm fucking starving, Squid! What did you eat today? I ate nothing! Nothing! I worked!
Y'all, Miguelina, do you have the one that they put to heavy metal? Jordan found it. Thank you, Jordan. There's one that's put to heavy metal. The video is super loud. Yeah, it might be, but we need it again. There's one that's put to heavy metal as well. But look at this. This woman.
I worked 10 hours! All I want is Wingstop! That's a little excessive. That's a little excessive. CEO is angry. I'm fucking starving, Squid!
I'm fucking starving, Squid. They're like, this is a little excessive. I'm fucking starving, Squid. She's like, just drive. We're going to watch this one more time. I feel her.
I worked 10 hours! All I want is Wingstop! That's a little excessive. That's a little excessive. CEO is angry. I'm fucking starving, Squid! What did you eat today? I ate nothing! Nothing! I worked!
It's the red eyes for me that she's just like, I ate nothing. I feel that in my soul too. Hold on. We've got one more. We've got the heavy metal version. This is the version that made me want Auto-Tune the News back because I miss Auto-Tune the News. So we're going to do one more because it's a fucking bop. To all of my moderators and Miguelina, you all are the best. And I love you. Hold on. We're going to turn this up a little bit. Chat, you're welcome. Am I going to be late for a call? Yes, but I don't care because I feel her. I absolutely do. All right, here we go. I miss Auto-Tune the News. And I love that they made it metal. We're going to do it one last time because I relate. I just relate. But the metal is so fucking good. It's stuck in my head. So for all of you that needed that song with the ukulele out of your head, here it is. And for all the ADHDers in the chat who resonate on a soul level with I ate nothing today because it happens too much. Yeah, we're gonna just do this one more time. Oh my God, you guys are like, this needs to be the food court swoop. Maybe. Get her Wingstop! Get her Wingstop! Fucking drive.
I'm fucking starving, Squid. What are you doing today? I ate nothing.
I get it. I get it. It's the way that the camera reflects in her eyes, though, that she is just like, I get it. So now it's in your head. I ate nothing. It's so good. I love it so much. Lawners. I feel for her. Get her a Wingstop sponsorship, y'all. Get her a Wingstop sponsorship. All she wants is fucking Wingstop. I want to know what happened that made her friends start recording. Like, what was she? Because she's like, I work 10 hours. All I want is Wingstop. Fucking drive. Like, what was going on in this car after her work day that they were just like, what we need to do is record this. I have questions. I have so many questions, but I'm here for it. I'm here for it. This gives me a giggle. But the friend's like, that was a little excessive. She's like, what? I ate nothing. I feel her. All right, y'all. The metal cover is my favorite part of it. We will drop the links in the chat. And, you know, I love the chat. Real Friends would have gotten her Wingstop. I feel like they're driving to Wingstop as this is happening, but the drumming is so good. She is hangry as fuck. Oh my God, this could be a Snickers commercial. It's like, you're not you when you're hungry. Maybe Wingstop needs to take it. You're not you when you're hungry. So for all of you, I feel it. Hopefully this has replaced the other music we've talked about so much in your brains. And I get it. I get not eating all day. I have worked very long days without eating and gotten done and lost my mind. And my husband's like, how are you? I'm like, I'm going to pull over and grab Cheetos and a Coke because that seems like a meal right now. But you don't come here for dietary and health advice. All right, y'all. Yes, they're definitely not driving fast enough to get her Wingstop. So with all of that, y'all, it is time to go. Lawnards, thank you. I've got to go. Somebody get her a Snickers. Exactly. I will talk to you soon. Miguelina and the moderators, thank you for making that happen with the fucking swiftness of light. You are the best producers, and I appreciate you. Lawnards, thank you for being the best parties on the internet. It's true. Hunger does alter your personality, and her friends are mocking her, and she's like, I will kill you. My kid's in the middle of band camp. I can't wait to show him this when he gets home and be like, how you doing? Because there are days in band camp where it's too hot, and he's like, I can't eat because I might puke. I'm like, reasonable. I'm going to send him this. All right. Swoop with a goat scream at the end. I ate nothing. Hold, please. Hold, please. We are saying goodbye. I promise. But, it needs a screaming goat. Lawners. I'll see you around the internet. Please go download Queen of the Con Season 4. Thank you for supporting my new podcast that I am a consulting producer on and contributor to. You will hear lots from me in episodes 1 and 2. And then it's dropping weekly. We gotta go. Bye. You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.